Honorable guests, ladies and gentlemen, welcome to the second day of the Asian African Legal Consultative Organization Annual Arbitration Forum 2023, resolving differences in a changing world by staying true to the Bandung spirit. It's so my pleasure, great pleasure to meet you again. I'm MC Yoile. Hello everyone, good morning. Good morning. We have now come to the panel sessions of the forum. Here are some housekeeping items for you. There will be a Q&A sections after the speakers sharing for each section. We welcome guests on site to scan the Q&A QR code to leave your questions to our speakers. The participants joined by Zoom may submit your questions in the Q&A chat box after or during the presentation. To continue the first day forum, let's start the panel session 6. Set the focus discussion, trends of mega infrastructure project disputes. May I now invite the moderator of this section, Professor Teresa Zhang, GBM GPS SCJ, President of the 59th Annual Section of the AALCO, Co-Chair, Asian Academy of International Law, former Secretary for Justice, the Government of the Hong Kong Special Administrative Region of the People's Republic of China. Let's welcome Professor Zhang. Please also welcoming the following speakers to join Professor Zhang for the discussion. Mr. Jin Chen, Senior Partner, City Development Law Firm. Mr. Chen, please. Mr. Liu Libing, General Legal Counsel and Chief Compliance Officer, China Merchants Port Holdings Company. Mr. Liu, please. Ms. Jill Miller, Legal and Governance Director, MTL Corporation Limited. Ms. Miller, please. So our moderator and speakers, the floor is yours. Thank you.
Good morning, everybody. Thank you very much for coming to the second day of this AALCO Annual Arbitration Forum. And I think it's a great pleasure that I have the opportunity to moderate a second session in this particular event. And this particular session is also a very interesting session. It's a sector-focused discussion and it's trends of mega infrastructure projects. Now, I think in the current era, there are a number of major infrastructure projects, from rails to highway projects to ports, that are being constructed around the world, especially, if I may say so, in Asian and African countries. And they could be from contractors and investors from Asian and African countries, but also from the Western world that perhaps are investing in these projects. Now, the trends in which, I should also say that, as you all know, disputes are almost inevitable in construction contracts. It's a matter of how you handle them that is most important. And in order to know how to handle them, it's important to know the trend by which they are going. In other words, you plan for it, you manage the disputes or differences, and then proceed along the way. Now, we have here today 3 very eminent speakers who will be able to give you a very good and broad perspective of what is the latest trends that are happening in this area. We first have Mr. Jin Chen. He's the senior partner of City Development Law Firm, and he has also been participating in the World Bank's doing business assessment for a number of years. So his experience in construction projects is not to be overlooked. Now we then have Mr. Liu Libing. Mr. Liu is going to speak in Putonghua, and if you need your SI, please, I think the microphones and the system are outside, so you can collect it. 刘立斌那个先生呢，他是现任的招商局港口集团股份有限公司的总法律顾问、首席合规官，上海国际港务集团有限公司的监事。他的经验在处理港口的建设、 会是很有关键的，因为在之前他也做了很多其他，包括在中间啊，等等的业务。更有趣的一个经验，刚刚那个陈军也说了，他原来在这一个场合也碰到一个以前建委的一个同事，因为刘立斌先生呢也以前在深圳的建委所呢也是当过律师的，所以挺有意思哈，挺有缘分。Our third speaker is Ms. Jill Meller. And Jill is the Legal and Governance Director of the MTR Corporation Limited. Now, of course, MTR is a Hong Kong company, but as you all know, MTR has had a large number of projects, not just in Hong Kong, but in various parts of the world. In other words, how and what MTR does in handling their disputes are very interesting. And Jill is going to share with us the perspectives of how MTR generally handle their disputes. I think I would say that so well that even when I remember I have been either engaged as arbitrator or appointed as counsel involving MTR, very quickly they're able to settle. Now that, I think, is a very sensible move because apart from lawyers, no one should get involved in disputes. That's what I would say. So we'll hear from Jill how she handles as the lead legal advisor handling all these matters. So I'm going to go in the order that they are seated to my right. We'll start with Mr. Chan, who will start with some trends. Thank you.
Good morning, distinguished guests. It's a great honor to have these opportunities to speak at this forum and share some of my observations on the trend of dispute settlement relating to the international mega infrastructure projects, especially those involving the participation of Chinese companies. History is a mirror. It can help us to summarize the past and to predict the future. So first of all, please allow me take a few minutes to briefly review the history of Chinese participation in international construction business. The China Construction Engineer Corporation was the first Chinese company established in 1978, specialized for the offshore construction project. In the following year, 1979, China Highway Bridge Engineering Corporation, China Civil Engineering Construction Corporation were established. In addition to the China National Complete Plant Import and Export Corporation, those four state-owned enterprises has taken the lead in carrying out the international construction contract business since 1979. The period from 1992 to 2003 was a decade in which the China economic growth remained more than 10% per year. So at this period, the China's international construction business shows the following character. First, the business scale and the global market share. The international influence continued to expand during the period, but the global market share was still small. Until 2003, there were only about 1,500 enterprises in China which were licensed to operate the international construction project. Second, the global market diversification strategy has achieved its initial results. In 2003, the number of countries which involving the participation of Chinese companies has expanded about 160 countries, with an increase of 84 over the year 1992. There has been a breakthrough in the way of international construction contract, and the more project requires capitals funded by the contract. From the year 2004 to 2017, as the world annual economic growth reached 5.4%, which is the highest in the past 20 years. So the global construction market showed a rapid growth. In 2004, the value of the new international construction contract signed by the Chinese company exceeded $20 billion for the first time. And since then, to 2017, the development of the international construction project has entered into a period of rapid growth. During this period, the merger and acquisition of international contractors become frequent. The contracting models underwent profound changes from the traditional general contract to turnkey models such as EPCs, and the contracting plus capital model such as BOT, BT, or PPP models become popular. And the financial abilities of the contractors was continued stressed. In the past 10 years, China's new contract for international construction project has successfully achieved a twofold jump. It reached $100 billion in only 4 years, and take another 7 years to reach $200 billion in 2015, with an average 20% annual growth. The increase in the mega construction project has promoted the transformation of the contract model. The various contracting models, such as EPC, EPCF, PMC, BOT, PPP, has become the main scheme. And secondly, the 80% of the Chinese company's business is concentrated in the Asia and Africa countries. And half of the business is focused on the countries along to the Belt and the Road. So take the promotion of Africa's industrialization process as the starting point. The Chinese companies have been actively participating in infrastructure projects such as highway, railway, ports, airports, and the logistics hubs. So for the period from 2008 to 2017, Africa became the second largest market for the Chinese contractors, which is accounting for an average of 34%. And together with the Asian market, which is about 48%, Africa became the region with the second highest concentration of the construction project for the Chinese companies. However, in 2018, the world economic slowed down from the previous year, and the Belt and Road Initiative continued to advance in the direction of high-quality development. The international construction business was facing challenges, such as the innovation of development model, the business upgrading, especially during the global pandemic since 2020. So, ladies and gentlemen, if we look at the history, I can summarize the following 5 trends which I would like to share with you. The first trend, after 40 years rapid development since 1979, the Chinese international construction business has become an important part and the method for the Chinese enterprise to go globally to participate in international economic cooperations. And further, with the deepening the Belt and Road Initiative, this method, for sure, will continue to develop for a longer time in the future. Second, with regard to the topic, the mega infrastructure project, the numbers of projects with a contract value exceeding 10 million, if we use the contract value, $100 million has increased year by year since 2004. But the maximum amount of a single contract actually decreased since year 2020. And the large construction projects are still mainly concentrated in infrastructure, such as transportation, energy, and communications. So those construction projects in the above-mentioned industry will be the main battlefield for future dispute. The third threat is more than 80% of the China's offshore construction projects were concentrated in Asia and Africa, which will continue to focus on the Asia and the African market in the future. This means the most of future dispute settlement for international infrastructure projects will take place in Asia and Africa countries. Therefore, the demand for consultative and settlement mechanism in construction disputes among Asia and Africa countries will continue to increase. So obviously, it becomes necessary to explore, build, and develop more ADR, including dialogues, consultation, mediation, adjudication mechanisms at different levels. The fourth threat, based on my view, is that more and more mega infrastructure projects, such as the Haipeng Power Station project, the toll road project, and the new energy project, require fresh capital. So financing becomes a core driving force for those projects in the future. And it also becomes an important element for Chinese companies to compete in the global market. The business model will also move from the traditional construction model to EPCF or FEPC, or even a new model with the integration of investment, construction, and operation by a single contract. In the circumstances, the future dispute arising from such infrastructure projects, which have a longer construction period, over decades operation cycle, and large capital requirements, will escalate from the traditional commercial dispute to the cross-border investment dispute settlement. So on one hand, it will become necessary for more international arbitral institutions, such as AALCO, that can handle both commercial arbitration and investment arbitration, to actively participate in dispute settlement. On the other hand, a considerable number of the bilateral investment protection treaties signed by China need to be revised and improved. It is suggested to include the EPC contracting model or even the new integrated investment construction operation model as part of the definition of the qualified investment, so as to give the future dispute the opportunity to take advantage of the dispute clause under the BITs. Finally, as the Chinese constructor has changed from a traditional contract to a project financing operator or even an investor, there will be more application of China's standard in such mega project. If we look at example of about 600 projects by Chinese enterprise along the Belt and Road, the adoption of China standards accounts for 35%. The standard of the host countries accounts for 25%, and the remaining are using American, British, and other standards. So geographically speaking, the Central Asia and the South Asia countries have a relatively high degree of acceptance of China standard, such as there's an oil depot project in Myanmar, which completely adopt China standards. So in general, the application of China standards in the field of electrical power, railway, communication industry is relatively strong. for example, in Africa, the Ethiopian Djibouti Railway adopt the China standard. So you can see in the future, it can be anticipated that the dispute over such international engineering project will become more frequently around the identification and understanding of the relevant China standard. So my dear guests, due to the time limit, I can only share those views for the time being, but we can still continue our discussion on the topic at a later stage. Thank you. Thank you for your attention.
Thank you very much, Jean. I think the 5 trends are particularly relevant, and I must say I totally echo the Chinese standards one and the use of the AALCO arbitration centers, as well as the financing being one of the issues. I think I can see that coming. I've already seen 1 or 2 such disputes floating along the way. So as Jean said, we will no doubt discuss a little bit more during the Q&A session. I have a few questions, but I think for now, we will move to Mr. Liu Libing. 刚才已经介绍了刘先生。刘先生呢，今天跟我们主要谈的就是分享他在处理那个海港时候的一些碰见的一些常见的问题，而且呢也会跟我们分享一下他怎么去选择一个仲裁的一个机构，好吗？谢谢你，刘先生。
各位朋友，非常高兴受亚非法协香港区域仲裁中心小峰主任的邀请，亦非常荣幸能在郑若华司长资深大律师的主持下参与今天的会议讨论交流。借此机会，我想和大家分享的主题是大型基建项目常见法律争议及解决方式考量，主要是3个小的部分。第一个是介绍我所在公司的基本情况，第二个是我们在企业布局全球开拓运营过程当中常见的法律争议，第三是我们在过程当中选择争议解决方式的主要考量因素。我所在的公司叫招商局港口集团股份有限公司，2018年在中国深圳证券交易所重组上市，股份代码是001872。旗下招商局港口控股有限公司则在1992年就在香港联交所上市，股份代码是00144，是在深圳上市、在香港上市的第一批红筹股之一。招商港口始终致力于建设高质量的世界一流的港口投资开发及营运综合服务商。我们从深圳西部港区起家，历经30年发展，逐步在中国大陆，特别是沿海建立了完善的网络布局。2008年开始早出国门，布局全球，开拓海外。截止2022年，招商港口在全球投资主控及参资港口50个，分布于6大洲、25个国家和地区，其中中国国内主控码头11个，包括深圳西部港区、湛江、汕头。重要的参资企业包括上海港、宁波舟山港，我们都是第2大股东。海外主控码头有3个，巴西的 TCP， 包括斯里兰卡的 CICT、HIPG， 以及重要的参资企业位于非洲吉布提、尼日利亚、多个诺美以及其他全世界各地。根据独立第三方的行业咨询机构的统计数据，2022年我所在的公司集装箱吞吐量为1.365亿万标箱， 散杂货吞吐量5.47亿吨，其中货物总吞吐量、货物权益吞吐量位列全球第一，集装箱总吞吐量排名第3，业务规模已经可以说是进入世界一流前列。我们从08年开始到现在，经过10几年的全球布局、投资运营过程当中，经常涉及到港口、园区综合开发等大型基建项目，亦无可避免的发生了不少的法律争议。据企业所遇到的争议类型来讲，我们大概主要分为以下几类。最常见、最多见的是合同纠纷，涉及到港口、运营、园区开发、仓储、经营合同等相关争议。其他的争议也包括港口船舶的碰撞或者损坏、货物的损失纠纷，以及个别国家地区发生的土地使用权的争议、环境法的违规，包括个别的行政纠纷。选择争议的方式，我们选择争议的主要方式要取决于争议本身的性质。在过程当中，针对一般的行政、环境污染纠纷、土地使用权的争议，我们大多的选择的是当地的司法诉讼，而最常见、最多见的合同纠纷，一般会优先选择仲裁，也包括其他多层次的综合式的解决方式。选择合同纠纷，一般选择仲裁，我想在座的各位专家同仁也大清楚，因为仲裁本身它面临着其他司法机构无法比拟的优势，这些优势当然包括自主的选择性，当事人可以自主选择仲裁机构、仲裁员的主庭、开庭的时间、地点、运用的语言等，赋予了当事人较多的灵活性。第二个，仲裁本身的中立和公正性。第三，我觉得最重要的是专业性。像港口、园区开发涉及到非常专业的技术和法律问题，相比其他的司法机构，我认为仲裁庭的组成它有更广泛的仲裁员的选择，基本上是行业内最专业的仲裁同事啊，可是也对专业技术和法律问题有非常深的了解。当然，仲裁其他的优势包括效率、保密。保密也是一个非常重要考量的因素，因为企业商业秘密和敏感信息大多情况下不希望公之于众，所以选择仲裁不开庭审理是我们优先选择一个重要考量的因素。当然，作为在中国大陆和香港两地上市的企业，我们立足香港30年，如果说选择仲裁，能在香港进行仲裁，当然是我们最主要的考量因素。我觉得除了刚刚说的一般的仲裁机构所具备的优势以外，在香港进行仲裁还有3个特别大的优势。第一个，优良的国际法治环境。香港是国际金融中心和商业枢纽，背靠中国大陆，连通世界，具备超级联系人的角色，有丰富的法律和专业资源，并且相对独立、透明和稳定的法治体系。在香港的仲裁效果在全世界能够受到广泛的尊重，并能够得到认可和执行。第二个，相比其他地方，香港有多元化的专业仲裁机构选择，目前包括亚非法协、香港区域中心、香港国际仲裁中心等多项选择，可以赋予当事人更多的选择。第三，我想特别分享的是，作为中国的企业，地位的提升、话语权的增加，也是我们能够自由选择仲裁方式的重要考量。随着中国几十年的发展，已经走上了世界的舞台中央。作为中国企业的一份子，我们更感受到了在国际化的过程当中，我们可以更加自信的在商业谈判当中能够选择我们自己的合理的诉求，包括争议解决方式的诉求。 我认为这个对我们这种企业来讲是一个特别重要、最重要的因素之一。以前我们是学习者，我们是跟随者，所以我们在商业谈判中没有选择。但是现在我们可以自信地说，看看我们中国的企业，我这个企业是全世界至少中国最大的公共码头服务商。我们20多个国家地区，50个港口码头，我们1年的利润能够几十亿，所以我们有可以自信的去做商业的谈判的选择，包括仲裁地的选择。如果能够选择香港的仲裁机构，那这几年我觉得在我们小峰主任的这个大力推介下，我们也对亚非法协香港区域仲裁中心有了非常深的认识。相比其他的仲裁机构，我个人的理解，亚非法协香港区域仲裁中心它本身还有3个优势。第一个，各界的鼎力支持。亚非法协香港中心得到了中国中央人民政府和香港特区政府的大力支持，受亚非法协成员的充分肯定，具有香港特区承认的类似国际组织的独立身份，在资产、档案，包括仲裁文件等方面有不受侵犯的特权和豁免。我认为这个也是个非常大的优势。在国际竞争、在数据保护、在各种这个情况下，我认为这一点优势也是非常值得大家考量。第二个优势，我觉得是创新完善的争议解决体系。我们了解到中心设有线上和线下的争议平台，特别是网上争议平台有强大的技术支撑，完全可靠、安全，配备了附加的功能，可以让当事人在随时随地在电子设备上使用尖端技术解决问题。我觉得这个效率、成本是当事人，特别是企业非常考量的一个因素。第三个，我们也了解到，这个中心有证据其资产保全的优势。区域仲裁中心是目前香港唯一一家根据国际法成立的仲裁机构，在仲裁中心开展仲裁后，受惠于香港特区法院和内地的相关协助保全有关安排，我们当事人可以及时直接在内地法院申请临时的救助措施，以及保全证据。总的来说，我特意学习了一下，这个郑若骅司长在任的时候，在19年，我记得曾经提出了香港要建设成为亚太国际法律争议其解决中心这个提法。现在我想，香港正在建设这个中心的过程当中，香港的仲裁机构，尤其是亚非法协中心所具备特定的优势，既有机会为企业当事人提供高效便捷解决国际争议的方式，更有可以为维护香港超级联系人及建设亚太国际法律及争议解决中心的声誉做出应有的贡献。作为企业，我们非常愿意全力支持并尽可能优先选择香港的专业仲裁机构，更非常乐意与来自亚非所有的朋友一道，为促进亚非法协的成员国、企业和人民进行更多更好的合作交流。非常欢迎大家到中国深圳、到香港、到招商局港口。谢谢。
谢谢刘先生的那个介绍，非常清楚的介绍了香港的独特的优势，而且呢，也把亚非法协香港区域仲裁中心的有一些独一无二的优势，也把它说出来。这一个呢，是非常正确的，我也非常认同。这一个对那个亚非法协的相关的国家，可以用亚非法协下面的6个仲裁中心，包括香港在内的，都是一个非常好的一个信息啊。So I think thank you very much, Mr. Liu, and we would now like to see how MTR handles their disputes, and we're very happy to have Jill to share it with us. Jill, please.
Good morning, everybody, and it's fantastic to be here this morning, so thank you so much for the invitation and to my fellow panelists for their astute observations. So for those of you from Hong Kong, you will know well that MTR is the organisation entrusted with the building, operation and maintenance of Hong Kong's mass transit railway system under our corporate purpose statement of keeping cities moving. But those of you from outside of Hong Kong may not know so well, as Teresa mentioned at the start, that MTR also has operations in a number of geographies around the world. So we have operations in the UK, in Sweden, in the mainland of China and in Australia. And in the mainland of China and Australia, we're involved there in the construction of new rail infrastructure. But let's come on to talk about mega infrastructure project disputes. And perhaps before I touch on disputes, just to talk about a few of the features of mega infrastructure projects, which I think help to explain why the disputes are so complex. So mega infrastructure projects are, by their very nature, expensive, and they take a long time to plan and deliver. They are technically complex, with major engineering challenges to resolve. So here in Hong Kong recently, we had 5 railway projects to deliver. And during the course of delivery, we had, I think at one stage, 8 tunnel boring machines under the ground here in Hong Kong. And for those of you that have travelled through Admiralty Station, there we had the challenge of building a huge underground cavern underneath 2 existing operating railway lines. And given the expectations of the public here in Hong Kong, we had to keep those railway lines running at all times during construction. They're also commercially complex, particularly if you're operating outside of your home jurisdiction. You have supply chain challenges to face, labour challenges, difficult insurance arrangements, currency challenges, again, if you're operating overseas, and complex legal documents, often with huge liquidated damages payable if projects are not delivered on time and within budget. And fourthly, they normally involve a large number of different parties, often with the government as the ultimate client. You may then have a delivery partner like MTR, who will itself have contractors and consultants, funders, joint venture partners, and even the broader community are really a stakeholder in the delivery of these mega infrastructure projects. And so it's no surprise, really, that the disputes involved are similarly complex, involving large sums of money and often many parties. So how do we seek to resolve them? Well, in our standard conditions of contract here in Hong Kong, we have a multi-tiered dispute resolution process. Firstly, with submission of a dispute to the engineer. Secondly, with compulsory mediation, although of course you do need both parties to play ball. And thirdly, with arbitration. But we also use a number of non-contractual processes, and I'll come on to give you a few examples of these. Senior party negotiations, for example, or a non-binding, without prejudice, third-party assessment, particularly to consider a specific technical issue that's arisen and is really causing a challenge between the parties and inhibiting their ability to come together and resolve the dispute. So why do we go for this multi-tiered kind of approach? Well, it enables you to use separate and distinct appropriate dispute resolution mechanisms as the dispute escalates. And it really acts as a filtering system. So some of the less complex disputes or issues can be resolved at an earlier stage and a lower level, leaving only the really challenging disputes requiring more extensive procedures, extra time and costs to be resolved in a forum like arbitration, with a view, of course, to saving the parties time and cost with minimum disruption to the projects. Because I think, for me, that's one of the key factors behind trying to resolve disputes on mega infrastructure projects, is that the interest of the parties is to get the project delivered. And why in our process is the final step arbitration and not litigation? Well, Mr. Liu already talked about many of the benefits of arbitration and why it's typically the forum that is adopted for mega infrastructure projects. But there's a couple of points here on the slide that I did just want to focus on. One, obviously, being fairness, with both parties agreeing to the arbitrator and relevant specialists being able to be engaged. And in one of the examples I'll touch on later, I think the success of the mediation was really down to the identity of the mediator, who was very respected in the Hong Kong legal community and very respected by both parties to the mediation. Secondly, I'll touch on cost. And you'll often hear arbitrators talk about cost, talk about how arbitrations are cheaper than litigation. And I have to say, as the legal director of MTR, I perhaps don't always find that the case. I think the work that you have to do to prepare for an arbitration, the lawyers, the consultants that you need to get engaged are very similar to a litigation process. However, arbitrations absolutely do tend to be more efficient in nature. And therefore, for me, the cost savings really come into the fact that it's a more efficient and effective process, whereas litigation can tend to drag on for much longer, obviously with appeals and further escalations. And finally, neutrality. And I think this is particularly relevant for the regional arbitration centres of AALCO, which are not connected to any particular state. So if you are delivering a major infrastructure project for a local government, there is always that kind of sense that perhaps if you're adopting the National Arbitration Centre, that government is somehow in a slightly advantageous position. And so I think the neutrality of an organisation like AALCO is absolutely fantastic and incredibly beneficial. And here, of course, with the Regional Arbitration Centre in Hong Kong that was opened in 2021, that neutrality is protected by Hong Kong's very strong rule of law and some of the other benefits that, again, Mr. Liu touched upon. The fantastic talent we have available here in Hong Kong, the technology that's available through AALCO, and indeed, I believe the new success fee arrangements, which will be available as well through an AALCO process. So what are some examples of disputes that we faced and how we tried to resolve them? So I talked about getting senior representatives involved, and I'll perhaps give you just a couple of quick examples of where this has been very successful for us. The first was on a very large, very complex software development process for a new signalling system here in Hong Kong. Signalling systems for railways used to be about blocks of rubber stopping signals travel or bits of wire making the signals travel. But these days, it is all about software. The project was partway through. It needed to be delivered. It was a commitment that we had made to the Hong Kong government and to the Hong Kong public, because by implementing a new signalling system, you can generally increase the capacity of the trains. You can basically put more trains through the tunnel. And so it had to be resolved. And we wanted the project teams from both sides to focus on the delivery of the project. And so here we got very senior executives from both sides to get together to sort of remove the commercial discussions from the project team. And we were able to come up with a way forward that meant we could continue with the project and are working now very hard to deliver it. A second example of where we used senior representatives of the parties was in relation to one of our big construction contracts for one of our recent railway projects, which unfortunately was delivered a number of years late. And the lateness of the delivery of the project just meant that had we tried to stick within the terms of the contract, we would have been mired in disputes for years. And sometimes I think with these types of projects, with these types of disputes, you need to be brave. And so actually the senior side, the senior parties from each side got together and we moved from a traditional lump sum based construction contract to an incentivized open book cost based way of working forward, which was the only way we could see to get the project delivered. And of course, it's very difficult to prove that that was ultimately the cheaper, the more efficient way of delivering it, but I certainly believe that it was. We've used third-party assessment in a number of ways, and one example here again from our recent construction projects involved a ground conditions claim. And it was an area where the parties had very different views and were really just struggling to come to terms. So we said, look, what about we get an external expert? This will be non-binding, it's without prejudice. We can still cover the same ground if we want to later in mediation and arbitration. But a little like mediation, it was just a way of bringing the parties together, of moderating their expectations. And ultimately, we were able to find a solution, which meant we could resolve the issue and move on with the project. We've used mediation, sometimes successfully. For me, it tends to depend, I mentioned the identity of the mediator, but also the commitment of both of the parties. And so we've used it both successfully and also unsuccessfully, where we just couldn't get our contractor to commit to mediation. So we did end up in an arbitration process. And we have, of course, also used arbitration, but we've tried, as Teresa mentioned at the start, to reach early settlements through arbitration. So again, use the early stages of the process of a way of measuring the parties' expectations, of bringing them that little bit closer together so that hopefully we can see a way forward. So in conclusion, there is no one-size-fits-all when it comes to resolving disputes on mega infrastructure projects. We certainly favour a multi-tiered approach for that filtering region that I mentioned earlier. And we found that these different approaches are appropriate depending on the stage of the project, depending on the nature of the dispute, and depending indeed on the parties that are involved. Because the key with these types of disputes is the business relationship between the parties that allows the project to get delivered. Thank you very much.
Thank you very much, Jill. I think your ways of handling the disputes are particularly worthy of learning for all in-house counsel. For this reason, I think what Jill has highlighted to me and expressed very impressive to me, is that she looks at the dispute and find a way that is applicable to that, and then use that to resolve it, rather than to blindly just go through mediation or blindly just go through arbitration. And I think that is a very wise way in which we can manage projects, and the experience that you have shared are extremely inspiring in that sense. Now, I think we still have some time. I believe I have until 10:30. 10:30. Yes, okay, good. Now, I'm happy because I have so many questions. Let me start again. Whilst you start thinking about what questions to ask, I see some hands putting up now, quite a few. So you see your talks have been very inspiring. But let me start by echoing the views of all our speakers about the AALCO arbitration centers, the uniqueness of it. I think I always look at arbitration centers and in this way. I think there are generally, I would say, 4 types of arbitration centers. The first would be the ones that are set up locally. You would be a local body that set it up, either related to the government or by a certain group of people locally. So you would have a number of arbitral institutions that are local to that particular city or that jurisdiction. Then you would also have another type, which are based on the general chambers of commerce of either that particular country or perhaps the international chambers of commerce, the ICC, as we all know. And for example, the Stockholm Chamber of Commerce also is based on a number of corporations, including international corporations that set up arbitration center. So there's 1, there's 2, a little bit more sort of international. Then at the far end, before I come to AALCO, at the far end would be those arbitral institutions that are set up by treaties. Take the example of the Permanent Court of Arbitration, the PCA. That is set up by treaties of a number of states that agree to set it up and allow it to operate in the way it did. Look at, for example, the World Bank, ICSID. It has the ICSID Convention, which of course also a treaty that allow ICSID to operate in the way it does. So that is, as it were, the far end, the one that has most international element and probably most in terms of neutrality. Then we come to AALCO. I think one of the very important things a lot of people may not be aware is that with AALCO, the 47 member states, which are all Asian and African countries, they've actually all have to agree before the arbitration center can be set up. So therefore, with the 6 arbitration centers, starting from Kuala Lumpur, all the way as the first one, and then all the way to Hong Kong, I think as our Secretary General of AALCO mentioned yesterday, all of these were set up with the consent of the 47 states. So they are not, and of course AALCO is an international organization recognized by the UN. And so whilst it is not set up, the arbitration centers are not set up by treaties, they are arbitration centers that are actually backed by an international organization that has 47 member states, and their neutrality and their internationality, as well as the uniqueness, the privilege and immunities that are given to these bodies become extremely important when you are choosing arbitration. So as I said, there are 4 types, starting with the local ones, the one with chambers of commerce, and then the intergovernmental ones, like AALCO arbitration centers, and of course, the treaty-established ones, like the PCA. So I think all of our speakers have highlighted the neutrality of AALCO. It's not just a matter of saying it, it is structurally protected that way. And I think there is a lot to be said when it comes to major infrastructure. And I think, as Jean, you were mentioning, they were Africa and Asia have become very important. Okay, so I thought I would like to share this perspective so that all of you can bring that home and consider the proper use of the arbitration centers that are under AALCO. Now, I believe there are 2 questions there. Can we have the, yes, Mohammed, Dr. Mohammed, please.
Yeah, here is Judge Goma from Egypt. Thank you very much for your informative interventions. I have many questions, but mainly I will ask my first question. In most of the developing countries, because of the deficit of budget, they going to the private sector, adopt, for example, PPP contracts or POT contracts in infrastructure building. So here, my first question: how the arbitrator, make a balance between the interests of the government as a public sector, which seek to the public interest, and the private companies or the private sector? How the arbitrator could create a balance in this regard? My second question is about the risk allocation. At your opinion, what is the best way to ensure the best of the risk allocation between the parts in those type of contracts like PPP, for example? And my last question is, as for Professor Jill, as you mentioned, those type of contracts is very complex because we have many parties and also subcontracts. Here, if the main contract, okay, has an arbitration clause and the subcontract don't have this arbitration clause, so here the arbitration clause will extend from the main contract to the subcontract, or what's happening in practice? And thank you so much for your time and intervention.
Right, I think 3 questions. Jill will answer the third. Can I ask Jean if you want to react to the first 2?
Thank you, Mr. Mohammed. The first question is about the balance for the Chinese contractor to consider either in the public sector and the private sector when adopting the type of contract, right? I think from the Chinese contract perspective, the social interest of the project will be the first, the key consideration. The second is, of course, the benefit or the profit from the project. When we talk about the BT or PPP model, basically there should be a grant of the right for the receiving either the power, electric fees, right? So it depends on the local legislations. Either the grant is allowed under the local law. The difference why the local countries to choose PPP model or BT BOT model is the lack of capital is one consideration. But sometimes they need the technology and the management skills from the overseas contractors. So in China, especially group companies, they have different sectors, companies in the group. One is take care of the investment, one is take care of the construction, one is take care of the management after delivery. So internally, they have the different, either we call it the business unit or department, but they, for outside, they act as a same group for the different stage of the project. So this is the second consideration. Yeah. Now, of course, they have to follow the local law. They have to follow local law when they discuss the terms, discuss the model of the contract. Yeah.
Thank you. So very much the risk management side on PPP is still back to the finance, the construction, as well as the management team that are implementing the project, being handling all these risks. 我想问一下刘先生，你们常常都会有一个前港后区，我记得没有错嘛？
前港中区后程
后程对
对对，
现在是前港中区后程。在怎样的情况之下，在刚刚提到的一个 PPP， 就是公营私营的合作方面，你们在这一些项目里面，前港中区后程，可能刚刚到中区的时候，有没有一些风险管理的一些特别的那个经验可以分享？
我们现在就是我们原先是港口码头起家，后来我们的商业模式就叫前港中区后程，前面是港口，中边是配套的园区，后面是城市开发。其实这个过程当中啊，涉及的基建项目啊，我觉得根据不同的国家地区，我们的评估是会分风险等级的。比如说在经济发展比较好的地方，那我们纯粹是按照商业的规则去做。但如果是在我们有些亚非的地方，就像刚刚这位朋友说的，当地本身的融资比较困难的情况下，这一点我觉得就是中国企业的优势。我们去外地投资，不仅能带去我们本身的投资，我还能够跟随我中国的银行、贷款，包括保险啊，这些能够一套的服务。我们很典型的在非洲一些地方，我们是申请的，国内的银行都是跟过去的。这个融资的问题解决了，很多问题就迎刃而解了。对，这个根据不同的地方不同的选择。
好，谢谢你哈。And Jill, finally to the question.
Sure, thank you. And perhaps if I could start actually with your second question around risk allocation, because I think this is very relevant then to when particularly you come on to disputes that may involve tiers of contractors and subcontractors. And I would say that a risk allocation has to be fair. You know, ultimately a client should want its contractor to make some money, and a contractor should want its subcontractor to make money, because if they're not doing, they're going to be looking for every opportunity to bring a claim against you. And we know that these projects are long, that they're complex. They often, despite the fact that clients hate change, they almost always do involve change, because there'll be different requirements from the client. There may be unforeseen issues like ground conditions that arise. So I think trying to seek a kind of a fair risk allocation is key, which then links on, I think, to when you get these kind of multi-tiered disputes. And often as the client here in Hong Kong, we find ourselves in some ways in the middle of the sandwich. So we will have a contract with the government, and the government obviously imposes certain obligations onto us in terms of the manner in which we deliver these projects. And we will then have contractors and subcontractors that actually do the work for us. And so every time we're negotiating a dispute or trying to reach a settlement with our contractor or subcontractor, we always have to have an eye upstream to think, how is the government going to look at this? Are they going to think reaching this settlement was the right thing to do? And so what we've tended to do, sort of despite the individual dispute resolution provisions in each of the contracts, whenever we've been reaching these downstream disputes, we try to get independent reviews of those to look at best case, worst case scenarios, to try and kind of give us some comfort that actually the conclusion that we've reached, the settlement normally that we've reached with our contractors and subcontractors is genuinely in the best interests of the project. And that is therefore something that we can sell upstream when it comes to the government kind of holding us to account in terms of our delivery. I think the other thing that you're seeing in a number of jurisdictions around the world, and indeed here in Hong Kong, which is really helping to protect the subcontractors, is legislation around pay when paid is the term that's often used in the UK. So trying to make sure that the money doesn't get stuck at the contractor level, but actually the subcontractors, who are often the people on the ground really delivering the work, are getting paid. And if they're not, providing a very speedy adjudication mechanism such that they can use that to try and make sure the money does flow down to the contractors. So I think it's a combination of new legislation, new regulations coming in jurisdictions that can help some of these multi-layer disputes, but also sometimes, again, as the client perhaps being a little brave in terms of the way that you're trying to line everything up, both upstream and downstream.
Thank you. And I think if I can also just supplement a little point about your situation, if, for example, the employer and main contractor has an arbitration clause, but the main contractor and the subcontractor doesn't have an arbitration clause, too bad. The main contractor will have to fight the arbitration and then with the employer, and the main contractor will have to litigate with the subcontractor. If they both have arbitration clauses, then most likely we can consolidate the dispute. But if not, then you have the main contractor will be the one that's going to have two battles to fight. And for all we know, he could lose on both, which is unfair, but he could possibly do that because they are multi-forum. All right. Now, I think we have a next question at the back and then to gentleman in the front.
Thank you, Teresa. My name is Terence Xu, and I used to work at BAC, Beijing Arbitration Commission, and now work at Jundu Law Firm. So I have two questions. The first one goes to Mr. Chen. As you mentioned about PPP project has been adopted in many mega infrastructure projects. I just wonder what's your comments on the Supreme People's Court on several issues concerning the trial of administrative agreement cases. Actually, the Article 26 said the arbitration agreement inside those administrative agreement is invalid. So I just wonder your comments whether it may or may not hinder the administrability of the arbitration in a given infrastructure project arbitration scenario. So my second question. 第二个问题是给刘总的，这个因为您介绍了这个招商港集团的情况非常有用，但是我就特别想补充一个问题，就是在您在涉外的这些项目当中，适用法在合同当中的适用法一般是做什么样的选择？是会根据投资的这个国家不同来选择呢，还是说我们会作为招商港集团的话会争取适用中国法 ？Two questions, thank you.
Sorry, can you repeat the name of the regulations?
就是那个关于审理行政协议的若干规定的26条，说那个行政协议第26条，行政协议当中仲裁条款无效，就是这个最高院的这个司法解释会不会影响咱们的可仲裁性的问题 ？PPP 项目？
是讲国内业务还是讲国际业务？
其实都涉及。举个例子啊，在北仲我自己办过一个案子，是一个外国的投资者。北京的一条高速公路就涉及到这个问题，他们是合同是和北京市政府签的，但是这个条款怎么去理解？
那可能这一个问题比较具体，对吗？所以也不一定太具体的讲，因为尤其你刚刚说涉及到一个案子，但是陈律师你也说一下吧。
好的，我简单说一下我对这个，我就用中文吧，因为涉及到是我理解是一个国内法，在关于 PPP 合同向下双方选择仲裁条款的有效性的问题，其实是一个国内法的问题。这个问题类似于我们 很多做 FDI 环节里边，外商投资跟政府和这个管委会签的一些投资协议和监管协议，到底是属于行政合同，还是属于平等主体之间的一个商事合同的一个认定，有点类似啊。当然 ，PPP 更多的还会强调它会有一个特许经营授予的一个行政属性，特别是在一个合同里边。那么，我想国内的最高院的给的这个指令，认为在3P 合同项下，因为有这个公共利益，以及加上特许经营的授予这么一个行政性的一个行政许可属性的一个行为，它把它定性为一个行政合同。我想这是我理解它的出发点。那么在这种情况下，按照国内仲裁法是解决的是平等主体之间的争议。那么如果是存在上下行政关系的话，它就不应该由双方来自行选择。所以这是我理解的3P 合同在国内关于仲裁条款有效性的一个法院最高院指示的一个出发点。我个人是比较认可这个方向的。特别呢，在解决刚才我提的这个园区的投资协议的时候，我们也会很清晰地告知我们的一些境外客户，一定要明确的意思表示，我们将来是去国内的法院的民庭起诉这个合同呢，还是去行政庭起诉这个合同？因为两个方向的救济是不一样的，在国内的法下是不一样的，所以在这种类似的合同里边，我们会做明确的约定，说清楚。是根据的民法典、根据的合同法签的这个投资协议和监管协议，还是根据的行政相关合同。但是3P 项目你没有选择，没有选择，所以呢，我相信最高院做这么一个指示性的意见，也是希望在上下不同法院的审理过程中，关于3P 项下仲裁条款的约定有一定的指导性的一个方向，而不会出现类案不同判的一种实际情况啊，这是我的一个个人的看法。谢谢，
谢谢你，刘总。
谢谢这位专家朋友啊，我想跟您分享一下，就是我们的企业确实，如果是之前我们刚早出去的时候，那确实是非常被动的，经常会出现2个不同的当事人、不同的国家去选择第3国的法律，当然是欧美的法律，这个成本的代价其实是非常高的。但是我想现在这几年以来，随着我们自己本身实力的提升，我们现在跟商务谈判，包括欧美一流的企业，我们现在也自己是定位为世界一流，我们应该比较平等的选择。关于法律适用，我们现在会优先选择我投资项目本地的法律，原则上，因为我觉得对大家都是便利的、公平的。但是第二个考虑，如果对当地个别地方的司法环境或者法律体系特别没有信心的话，那我们会选择相对先进的法系。比如说我们在个别的非洲国家，我们可能会选择跟对方协商，我们会选择法国的法语系，对，大概这个选择，这2点考虑。但是一般的不太可能会去选择双方都不赞同的第3方的，比如说英国、美国选择那么看起来高大上的，但实际上一旦发生争议，在争议处理过程当中，其实对双方来讲都是一个非常高的成本去研究它的法律，大概这个考虑。谢谢。
非常有趣。你为什么不选择中国法呢？
中国法律其实我想这个也客观来讲，对方当事人一般的也不会选择我，除非他来我这边投资本地，我到对方去，我尽可能，如果是能不选择本地的，对他的司法环境没有信心的话，我会选择第3方先进的。这有个接受程度。
我肯定要去你们拜访一下。好，谢谢。Jill, you want to supplement?
对，因为我感觉我们也是国际化，你商业的运营过程当中，你需要灵活，原则需要处理。确实，如果你选择中国法律，人家也不会同意。 对，谢谢。
明白，明白。Jill.
I was just going to add an experience that we had, which was partway through a bid, and I won't say which jurisdiction it was in. The bidding entity changed, actually, the dispute resolution mechanism mid-bid from ICC arbitration to a local arbitral body. And when we asked why this change had been made, we were told, well, because we've recently lost an ICC arbitration. Now, of course, this gave us, a lot of concern because the local arbitral body, we didn't feel had the talent and the experience necessarily to deal with the kind of disputes that may arise. Now, it wasn't the only reason that we didn't submit a bid for that project, but it did, it raised real concerns for us, which I think just goes to that point about choosing the right bodies.
Now you have AALCO arbitration centers.
Absolutely.
I think we have a question from Gaston here.
Oh, thank you so much for your presentation. I have two questions. The first one is dedicated to all the panelists. The Chinese expertise in mega infrastructure project has presented is indisputable. But when you go to Africa, I think you meet the expertise from the former colonizing countries in this mega infrastructure project. How do you overcome this competition? This is my first question. I mean, China has an expertise, but when China goes to African country, they might encounter the expertise from the former Western colonizing country. So there is a competition. How do they overcome this competition? This is the first question. And the second question, I think Teresa will be useful to answer this question because you have listed many international arbitration centers. And according to you, what should be the accurate criterion for the parties to choose these or other arbitration center? These are my two questions. Thank you.
All right. The first question, I think the most relevant person to answer would be Mr. Liu. 刘先生，你听到他的主要问题就是说，中国的企业去到这一些亚非国家，很多时候是一些以前是殖民地，那这个竞争肯定会有了，因为你进入人家一个后殖民地的一个氛围，作为一个中国企业，你是怎么去竞争，怎么去打进这个市场？
谢谢，您这个问题我们深有体会，因为我们在亚非，包括东南亚，现在布局有很多项目。我们的感觉是，进入一个新的地方，你确实首先要相当了解、熟悉当地原来的一些规则和做法，要充分的去研究分析，对比它的长处，对比它的短处。如果说优劣对比之后，你要心中有数，做好充分的准备。中国的企业长处在哪里？在强大的基建能力，一系列的综合性的技术人才，我们的投资配套的融资，不仅仅是投资本身，配套的融资跟进，这一个全综合性的考虑。而且我个人讲，就是我所在的企业，我们出去投资，确实不是纯粹的商业至上。我觉得这是中国企业的特征之一，商业考量是我们的重点因素之一，但绝对不是唯商业至上。我们是行稳致远，立足长远，到当地去发展，希望跟当地的朋友做朋友，能够长期的发展。所以我们的商业考量，我能占10%，我也可能只按6%的比例去做。我觉得这就是我们的优势。我们经过10几年的发展，包括在非洲的朋友同事，实际上应该理解中国的企业和原先欧美企业的区别。当然我是个人看法，不一定对，不知道有没有欧美的朋友。对，我们是这么做的。我们现在斯里兰卡、在吉布提、多哥，
You are right. what you say, and I'm very satisfied with your answer. Thank you so much.
I just add from my legal professional service, we always cooperate with the like European firms when we have handled Africa project, because we need the local experts plus the expert from the countries.
But one question: why do you collaborate with Europeans to act in Africa, whereas you also have experts in Africa?
We do both sides, because first we look at the jurisdictions where it still follows some colonial laws, legal systems, so we can have a more broad understanding of the legislations, the history. The second, of course, we need the local team, the professional team to help us. So normally we lead the legal service, we choose the best expert from the local in the country and the country where they have the colonial. So this is how we organize a team. Yeah. Thank you.
Thank you. And you want me to answer the question, is that right, Gaston? You're giving me an exam, all right? Now, the exam will start by it depends. If I am a local person from a jurisdiction, my first choice would be my local arbitral institution, because I feel much more at home. But as soon as it goes into an international transaction, it becomes not easy, because why would they agree to come to my arbitral institution? Of course, arbitral institutions nowadays are always neutral in the sense that it's not the locale, but the arbitrators involved, etc. But I would still prefer, like I was explaining just now about the 4 types of arbitral institutions, more like the institutions like AALCO, because it has that structural protection of neutrality and credibility. Each of the arbitral institutions around the world will tell you that you have our rules, and if you look at all the rules in the world, they are pretty much the same. Then you would look at the structural integrity, the structural aspect of it. Is it just a body that decides who goes on the council by just the council themselves, or is it going to have a very good system by which they vet and ensure that it is well represented? You want to see the secretariat, you want to see how it's all working, and how, like, for example, the Hong Kong Regional Arbitration Center is able to put together such a brilliant conference. These represents the ability of these organizations. So I think these are all the factors to bear in mind. It's very important to bear in mind that it's always a credibility, and also the fact that it is established by consensus, like I was explaining, and that gives that particular institution a lot of strengths. And of course, you need the other side to agree. And I think in the projects that we were talking about, the major infrastructure projects, a lot of them is in various African countries. So let us say it is in Nigeria, and we would still go for an AALCO center. Let's say the AALCO center, I hope it's Hong Kong, but let's say it's Hong Kong. Then at least Nigeria is a country, is a member state of AALCO. It has that trust. I think I've been given the sign that I have 3 minutes. I have one question. I think one question from this lady and one question from the gentleman behind, and we'll keep it short, please.
Thank you very much, Prof, and members of the panel. My question is, first, can you help with more explanation on the idea of pay when paid between the main contractor, the employer, and the subcontractors in a PPP? Then the second one is, also, can you help with some other live examples of the complex nature of contracts, such big contracts? That goes to Professor Jill, yeah? big contracts, the complex things that could arise? Is it on the part of the contracting clauses or on live situations that go on as the contract progresses? So just want to have this information. Thank you.
Sure, thank you. So pay when paid clauses are clauses that generally the contractor will say to the subcontractor, I will only pay you when I have been paid by my client. And so then if you end up in a dispute situation between the main contractor and the client, the subcontractor might, through no fault of their own, be getting paid. And we all know that the subcontractors tend to be the very small businesses, but actually they are providing most of the labour on site that's doing the bulk of the construction work. So these new regulations are effectively outlawing those pay when paid clauses. And so the subcontractor has the right to be paid despite whatever is going on between the main contractor and the client. So they were outlawed, I know, and this is showing, I've been in Hong Kong now 20 years, outlawed in the UK some time ago, and it's currently undergoing the process here in Hong Kong. Secondly, you talked about the complexity of contracts involved in a PPP project, for example. And my first PPP was back in London, on the London Underground. And I remember, you know, the day of signing, just the volume of documentation that was involved was huge. So starting from the project deed between the government and the consortium. We then, of course, had the joint venture arrangements between, we had 5 shareholders, each holding 20%. So it felt a bit like herding cats most days, trying to get everybody in the same direction. We then obviously had our funding arrangements with the external funders, and then we had the supply chain arrangements on the design and construction side and the operation and maintenance side. So simply putting all of that documentation together in a way that the key obligations and risks flowed down through those different contracts so that the risks ended up in the right place to the question about risk allocation was incredibly challenging. But of course, then what you often find, as I mentioned, during a long construction project, you know, you think you know what you want to build at the start, but inevitably you will only have done a certain amount of design and you won't have been able to do enough ground investigation. And so these issues will come up through the life of the project that require the contract to be varied. And that, of course, then it introduces challenge and change about what's the impact of the variation from a time and a cost perspective. Likewise, in the operational phase, you can have challenges around, are we delivering the level for us of railway services that was demanded by the client? You know, are the number of trains running? Are they running on time? Have we got the right number of people? Are the stations clean enough? And so really the complexity comes, I think, from the initial setup, but then just through the types of issues that come up on these kind of projects. Sorry, that was a slightly long answer. Teresa.
That would be the last question, please.
Thank you very much. My name is Deborah. I am with the Permanent Mission of Ghana to the UN in Vienna. Ms. Teresa Chen, I think I have been a secret admirer of yours, and I recognize all the work that you're doing in this space. You have been inspiring to me, just to, from the backdrop of some of the issues that Dr. Gaston said. Arbitration has been an important means for dispute resolution, but we are all aware that it has its own challenges, and due to these challenges, UNCITRAL, for example, I am privileged to be part of the working group, and part of the reforms that we are attempting to bring to make sure that issues of member states and even investors are addressed. One of our issues have been geographical representation and neutrality. And I am very happy about the AALCO Regional Center in Hong Kong. I think that Hong Kong, personally, I think that there's so much that we can learn from Hong Kong, how you have brought it up to this international status. My question is that what is AALCO doing for Africa, because we need some of these regional centers in Africa. Madame said something about talent and experience, and a lot of these investments are in Africa, and we have a pool of resources in Africa. We have experts in Africa. We have people that are willing to have the experience, and because some of these forums are outside, it makes it very difficult. So what is AALCO doing, since AALCO is Asian African? Very happy to have a regional center in Asia. Does AALCO have any plans of having a regional center in Africa to bring aboard the talent and then the experience of Africans, and then also improve the credibility such that when there is a dispute, we don't necessarily have to choose outside forums, use the UK, so that we can move along. And I think that, personally, I think these will feed into the reforms that we want and then resolve a lot of the concerns that we as Africans, we have. Thank you.
Well, thank you very much for that sharing. There are 6 centers: Cairo, Nairobi, Lagos, Kuala Lumpur, Tehran, and then Hong Kong. So I think what can AALCO do? Of course, I do not represent AALCO, but I'm sure in their mandate is the reason for setting up these centers, of course, is to promote arbitration and to facilitate the use of arbitration amongst AALCO states. So I think there is opportunity, and Nick is here, that he will no doubt to bring it to the AALCO meeting as to what can be done. Capacity building could be one, and then, of course, the annual forum like this one could be moved around in the world, in the Asian African countries, in order to have the experience shared in various places. But I thank you for the thoughts, and I'm sure that Nick will pass that back, and I will also pass back to the Secretary General on that. Now, I think we have really run out of time, so may I ask you to join me in thanking our speakers in the usual way. Thank you.
So much for insightful sharing. I believe we have useful takeaways. May I invite the guests on stage to step forward to have a video together? Yeah, ladies in the middle. Very gentleman. Okay, so have a look to the front. Don't forget the big smile. And also one, okay, please remain on stage. In order to express our appreciation, we have a tote bag with some souvenirs for you all. This will be Hong Kong style notebook bag and also the travel adapter. Hope you can always think of AALCO all the time when you're traveling. So one more photo together. Yes. Thank you so much. Thank you very much. And please be seated. Thank you so much for the sharing. I believe you all gained so much insight. Now we're going to have a refreshment break, and the next panel session will start at 4:45. For online participants, please stay logged in. 10:45. Yeah, 10:45 will be 10:45. And then now you can take some time to visit our booth set up by the Law Society of Hong Kong and also City Development's law firm. Also, don't miss the chance to interact with the robots by Robon. See you at 10:45. 10:45. Thank you. Hello, ladies and gentlemen. Our forum will resume very soon. May I invite you all, please come back to the hall. May I invite you all, please come back to the hall because our forum will resume very soon. Thank you. Hello, ladies and gentlemen. Our forum will resume very soon. May I invite you all, please proceed back to the hall. Our forum will resume very soon. Please proceed back to the hall. Stay tuned and see you in a bit. Hello, everyone. Welcome back to the Asian African Legal Consultative Organization Annual Arbitration Forum 2023. So now let's start our panel discussion 7, Understanding, Handling, and Resolving Sanction Protectionism and Supply Chain Disruptions. We have already on stage for welcome and moderator Dr. Anthony Liu, Gilsey SCJP, co-chairman, Asian Academy of International Law. Thank you so much. Thank you. And also, we would like to invite our following speakers to join Dr. Liu on the stage. Mr. Ken Lo, Chief Executive Officer, AMTD Digital Media Entertainment Group and AMTD Digital. Mr. Lo, please. Mr. Robert Lo, Divisional President, Greater China of CPA Australia. Mr. Lo, please. Ms. Minnie Siu, Partner, King & Wood Medicines. Ms. Siu, please. The Honorable Sunny Tang, Member, Legislative Council, Textiles and Garment Functional Constituency, Chairman, Hong Kong Productivity Council. Mr. Tan, please. So now our moderator and speakers, the floor is yours. Thank you so much.
Let us all sit down first. And first of all, so nice to see so many old friends this morning. And we have a very interesting and I think topical subject today. How do we deal with sanctions and also disruption to the supply chain? These are very, very topical issues, something which affect all of us, not only as either as public officers or as people in the industry or just an ordinary citizen. I mean, as we all know, really right after the Second World War, in fact, sanctions became a matter of state. Rather than previously, in fact, things like boycotts and so on, or nationalist movements. And because of the Cold War, and because the world has become a more difficult place, we have things like sanctions. And sanctions, in fact, come in so many different forms. We have, of course, the UN sanctions, which are highly focused. And at the moment, there are only 15, in fact, sanction regimes, which was approved by the Security Council. And they are very heavily policed by committees under the UN, and they in fact have short leases of life, and so long as the policy objectives are completed, then these sanctions are cancelled. On the other hand, we have different states, in fact, now involved in imposing sanctions on other people. And of course, the state that does this the most, mainly because it is, of course, the economically most dominant state, is the United States. But of course, the European Union also does that. Of course, it is a big conglomerate. And therefore, these sanctions affect every country. It affects industries and so on. And today, and these sanctions come in different forms as well. They come in forms of prohibiting, in fact, persons and entities within a particular country from dealing with people that that country designate as being undesirable people to deal with. Or in fact, sometimes they put in sanctions against exports or indeed imports by imposing additional tariffs. And things like the 301, for example, in the US does that. And of course, again, in terms of the thing that is most in the newspaper, of course, would be prohibition of exports of high-tech, and also, of course, prohibition of exports, sometimes even of the use of the internet. For example, Iran is very much part of that prohibition. And in fact, a lot of software is prohibited. To give you just an example, US entities are prohibited from dealing with various named entities in Iran, in Russia, and so on. And if they do, in fact, sometimes deal with these entities, they get fined by their own governments. But on the other hand, we do see a lot of exemptions because these sanctions, in fact, are often worded widely, and therefore they could cover a lot of people, sometimes people who might be quite innocent. And therefore, many countries in imposing sanctions, they do try to give relief to the situations where they feel innocent people might be affected. Now, which then turns into a big area of learning. if you look at sanctions law, it is a very, very big system, very, very difficult to navigate. And which is why we have here today 4 people who really know a lot about this and share the experience with you. Now, the first person I'm going to ask to speak is Sunny Tan. He's a legislative counselor, but also he represents the garment and textile industry. He will share with you his experience in there. The second person I'm going to ask to speak is Ken Low. Now, Ken is one of the global media companies headquartered in Hong Kong. He's the CEO. And he will share with you his experience in terms of sanctions and supply chain around the world, issues of that. The third person I'm going to ask you to speak to you is Robert. Robert Loy, he is an accountant. He's a practice head in terms of corporate finance and in terms of sanctions and the finance industry in Deloitte. And he would share with you his experience from his perspective as one of the big 4 firms in the world. Last but not least is Minnie Siu. Now, Minnie is a lawyer from a global law firm which is based in China, Hong Kong, and Australia. And she will speak to you about this whole legal system involving sanctions. Not an easy thing to talk about, but she will try to do this within 10 minutes. So let us then start. Now let me ask then Sunny to start. Sunny, you have the floor.
Thank you, thank you. I think I have, once again, thank you all for having me here. And, okay, let me see how to. Okay, I just want to get started with some background. As you all know, I'm representing the textile and garment industry. And textile and garment industry has been affected or been part of the sanction game for multiple decades. And we can hear, we can see, we can learn a lot from how things are being managed by the imposing country like US, like the EU, Europe, and how we as an exporting country, how we manage the whole situation during that time in this maybe 70s all the way up till now. It has been evolving, and we can see a lot of interesting points that I'm going to share in the next couple minutes. Okay, to start with, in the 70s, we just talked about the MFA, Multi-Fiber Agreement. It was an agreement agreed, I think, by a lot of countries. I think it's being coordinated through Yuan, and that was after the war, and a lot of the protection really comes from primarily Europe at that time, Europe and US. They have the purchasing power, and they want to figure out how to allocate quota to have an effective way to distribute their orders in different countries. And it's been packaging in a way that serves a lot of purpose. But one thing as a factory, what we know is we need to play the game so that we know where to produce, how many to produce, and who do I sell to. And at that time, it's very much against the fundamental of productivity, efficiency, or supply chain management, because where you produce is not being determined by where it's most efficiently being made, but it's about whether you have the quota. Okay, and at that time, if you notice, if you go back to the history, China accounts for a very, very small quantity of an export. And unlike now, you look at the textile apparel, the numbers a lot higher. So that is a very interesting phenomenon. And at that time, Hong Kong has been a very important player because Hong Kong has inherited all the technical know-how from Shanghai, okay, during the 30s, 40s. That we gain a lot of the technical know-how in textile and garment making, and also another group is from Guangdong, and it makes Hong Kong become a big textile hub. And we have been, because we are more international, we are able to sell products to US, to Europe, and be able to negotiate with customer and to deal with all these sanctions and the government and the politics. So we turned out to be working out quite well, not only in Hong Kong, but after Hong Kong, because quota will be full. Okay, quota means there's a limitation, but we want to do more, we want to sell more. So we are going into other countries. So that's why we have been going into, for example, our company. Because of quota, we went to Guatemala, we went to Mexico, Cambodia during 90s. Imagine, those are not the places that you enjoy going as a business travel. I still remember first time I went to Cambodia, I saw people carrying guns. And I don't think I want to be there for too long. Guatemala, think about how many times of transiting you need to do just to get yourself to the factory. And how you're going to convince people to work there, right? So it's just not easy, but that's where we need to make garments because of sanction, because of the tariff, because of the quota situation. But then people get smarter and smarter. We just talk about the fact that when you do sanction, there's always exemptions. Okay, so how do we effectively work with the importing country, let's say US? Where is the technical side to allow an exception to happen? Okay, sometimes we also call that lobbying. All right, so that is an area that how do we find the right political opportunity for us to be able to get more quota, or in certain cases in Africa. I remember Africa, I think Ethiopia, is quota-free, duty-free, because of certain political relationship that caused this kind of quota-free, duty-free. But then there's another interesting thing we call outward processing arrangement. Okay, I think lawyers are very clever and very creative. What they are trying to say is, yes, there's a sanction of importing of apparel. But then the lawyer, the custom lawyer says, what does that mean by apparel and before the item become an apparel? All right, so when you cut the fabric, is that apparel? No. When you stitch the fabric, put on your collar, is that apparel? No. What they call is the substantial transformation as the definition. So when you stitch the apparel into a three-dimensional form, that's apparel. What does that mean? It means that I could produce a majority of my work in China. And then I can bring the piece of goods to Hong Kong or Macau, I stitch it together and become what we call apparel. Then I use the Hong Kong quota and ship it to US. But my production cost can go down. So effectively, I have maybe 50% of my value creation content, my production activities happen in China, but using a Hong Kong quota. So during the sanction time, what I'm trying to explain to all of you is people are getting creative because it's politics, all right? In 2000, so 20-some years ago, quota system has been agreed that it has to be eliminated by phase, and China entered WTO. And that has become a big change because finally, goods are being made in the most efficient manner, that you see a big jump with the China production. You see the supply chain become stronger and stronger. Oh, sorry, before that, I missed one point that I couldn't see. Because of the fragmented situation, trading company, middlemen came in. Because they are very sophisticated, know how to communicate with the customer, knowing how to deal with the geopolitical situation. That's why you are seeing some very successful trading company, like Li and Feng, like the one owned by Alan Zeman, Co something, I forgot. So you can see a lot of very successful trading company because they are leveraging their expertise. So when there's a problem, there's also opportunities in the industry for some players. Now, let's go to abolition of the quota. One thing is middlemen start going down because you no longer requires as much to have a facilitator to help you, helping the brands or helping the factory. At the same time, supply chain partnership and basic consolidation happen. So it becomes very, very efficient, and that's why you're seeing the world with a deflation situation came out. Price has gone down. Why? Because inefficiency has gone down. Things are becoming cheaper and cheaper to produce because we don't need to make so many garments in so many different countries. Okay? Things become a lot more efficient. But at the same time, when it comes to 2018, things turn around because of Trump, because of the fact that he's creating China as an enemy. That makes people worry. But it's not only about, okay, I put in 301, I'm trying to do a tariff to stop China from producing. But they are creating China as a risk, as a political risk, political uncertainty, which is also being amplified by Biden right now. So the whole political risk situation has gone not to only the person who's giving out orders, but it's affecting how the board of directors is thinking about the supply chain. Imagine I'm the sourcing manager, I need to give out orders. But then my boss, the CEO, is being asked by their directors, who might be a lawyer, and say, oh, I heard about, we know the fact that there is a uncertainty on political risk between China and US. What if my goods cannot be shipped out? Okay, I'm going to lose a lot of business. What is your plan? Okay, but in fact, there's not much problem shipping from China. But then because there's a question being asked at the board of directors level, they have to have a plan. Investor may ask the same question. They have to have a plan. Then now what happened? Everybody's looking at deleveraging China in terms of production, disengaging China from the supply chain so that they could have the right answer to the board of directors who asked this question because politics, not because of the actual economic development as to how things should be produced. But unfortunately, that's the problem. I think I will leave some time for Q&A, but just finish with this. Going forward, what do we see? I think we are seeing that the situation will continue. We see that China's economic power will get closer and closer. It means the US will never give up. But we need to assume that we need to manage the uncertainty. And last thing is, if US is not very good in terms of how we serve the market in our industry, let's look for other markets. Mainland market, China market, in Southeast Asia. So these are the opportunities that we also see outside of sanctions. We just need to learn to live with sanctions. Thank you.
That's great, Sunny. During the MFA days, it was a sort of cat and mouse game that Sunny has been talking about. And all of these cat, of course, if you are the mouse, the cat is not stupid as well. Which is why you have all kinds of rules that have grown up, including certificate of origin rules and so on and so forth. Now, these have gone into the WTO from 1995, and all the rules, in fact, which go into the WTO is very, very interesting set of rules. But then, of course, the US has its own 301 regime, which sometimes clashes. So it's a very, very interesting story, something that we could discuss later on. Now, the next story, from another perspective, comes from Ken. Now, Ken is the CEO of a major global media company. And then in that space, he's going to talk to you about the problems of sanctions and the problems of supply chain disruptions. Ken.
Thank you very much. And I really enjoyed the sharing from Sunny a lot. And I also learned a lot as well from the textile industry. So from our perspective, that would be another industry, but also facing some of the protectionism or some of the supply chain disruption as well. So from us as a Hong Kong company, AMTT, we start our businesses in financial industries. We have 2 listed companies in US Stock Exchange, and we now foray into the media and entertainment sector 3 years ago. So by doing that, we are adopting a business model of merger and acquisition. Right? So we are not starting a media platform by ourselves, but we are sourcing globally on which target that we can acquire. So last year, we acquired a global fashion magazine called The Visual. So it has 31 countries, 80 editions covered. And this year, we also acquired another media platform called Art Newspaper, covering 17 countries, 30 editions. So what does it really mean? And also the implication to today's topic. And I think number one is for us that with the corporate DNA from financial industry foraying into a new industry, right? We need to learn and swim very fast, right? So that's number one. And 2 is we are not only looking at one particular market on the Hong Kong capital market financial movement, but we are interacting with our stakeholders and customers and readers on a global scale, right? So the first thing that we did and the learning that is relevant for today is what should we really do, right? If we're coming out from a local company into a global company. So the first thing that we are looking into is how do we protect or sustain our IP and trademark, right? Because every day in the media, right, with or without the advancement of AI, people can infringe you, right? So tomorrow there could be another person representing your magazine, talking to a celebrity, right, to take a cover shoot, right? Or, right, they may represent you on behalf of your name, right, without notifying you to interact with different customers. Third, and every day in the social media, you can have different fake social media accounts, right, where you only realize that aftermath, right? So that's why, I mean, for us, the first exercise that we are doing is working internally and externally is how do we ensure we have the adequate trademark being registered. And I think for that exercise, that is also tricky, and also we realize that sometimes, right, it's also very outdated about the whole trademark system is, right. We acknowledge this is what this is, but I think for a lot of the activities that we are going on, right, for example, if we talk about digital social media influence, right, is increasingly borderless, right? So we cannot define this particularly as one service that you need to register in a particular class. So for example, for a media company, for us, right, we do print, we do digital, we do social media, we do events, we do consulting, and it might, right, require us to register more than 10 different classes in one particular country. So imagine that number, right, multiplied by 31 countries, right? That's 310 trademarks that we need to register. We need to monitor on a daily basis to see, number one, anyone try to infringe you. Two, what is the renew date, right? The renew date will be different across the 300 trademarks as well. So think about all this administrative work that we need to put on, right, in order to protect the branding that we have in the global market. So I think this is the first learning that we have is when you are going into a global industry, how do you protect yourself, right? How do you protect not being infringed? So I think this is one very particular exercises, and also the cost associated is not small, right? No matter the registration and also the ongoing maintenance costs. I think the second thing is also about the infringement that we also experience on different occasions. So recently, we also received a lot of cases, and most recently is the celebrity just call us, right, and say, hey, I'm just doing the cover shoot for you. When will you post it, right? So we receive different inquiries on a global basis, right? And sometimes we just find out that, oh my God, you just shot with a person that infringed us, right, in Saudi Arabia, where we haven't have presence there, we haven't have team there. But a celebrity called us that they have shot with the official Saudi Arabia, for example, right? So all these matters, right, it turned us into a very firefighting mode because we cannot anticipate it, right? But we can only react upon it, right? And how would you go into the legal action, prepare all the risks, etc., etc.? So that takes time, right? But it might not stop the bad actors, right, to act against you. So I think this will be the second lesson as we are learning when we have markets globally is how would you turn from a reactive firefighting mode into a more proactive mode, right? And that goes back to the first item that I mentioned is should you even register all the IP trademark that in the markets you haven't been, right? So whenever people come in, you have a ground, right? You have evidence to prove that you are going to operate over there, right? So this is the first topic I want to share with everyone is the amount of work or cost or consideration that you need to bear in mind, right, when you run a global business. No matter today I'm a media entertainment or tomorrow you're a retail company, how you protect your IP, your trademark, how you prevent from the infringement, I would say that will be the art of science by itself. So that will be the first topic I want to share through this forum. The second, I would say, thing that I want to share is about the understanding about the different regulations appeared as well. So for media and entertainment, we all acknowledge that creativity is being imposed by having more talents joining us. No matter the talents are on full-time or freelance basis, right? And because especially right now it's a Gen Z economy, right? A lot of the people is a slasher. Right? They don't want to work for one company, right? They work for themselves. They want to work for multiple purposes. And more of our workforces, they choose to be freelancers than a full-time employee. So imagine about this, right? If you have 31 countries, freelancers working for you, how much knowledge you have across different labor law in different markets. That would be another like a head that you need to understand, right? What are the labor law? For example, in Hong Kong, we have the mandatory provider fund, right? Measuring about number of days that you work with a company. How does it count for a freelancer that work for you as well, right? Is that market labor law protecting them, or we have no clue for this, right? So this is another exercise I would say is, for me, by taking up this role is, I need to work super closely with lawyer, right? So I mean, a lot of time is spending time with the lawyer to really have a thorough understanding about what is the labor law of different countries is. Because if one freelancer just send you a check and ask you, hey, in my country, I need to have that kind of bonus as well. Is it true or not, right? Because we are not just working in one market, we're working in 31 markets. So this kind of thing, I would say, is also a supply chain disruptor for me is the talent supply, right? How do we maintain the talent supply, not disrupting our own business, right? But really can thrive for that, right? So that's why I would like to use this forum to share. Number one, if you are running in a global business or you intend, right, to expand your business in multiple markets, IP, trademark is something that you need to really take up as your top of the priority when you're forward into this, right? Because that not only just about protecting your own logo, it also stands your evidence of ground in operating in that business, and that is good for you if you run into any legal dispute. And second thing is about the talent supply, right? A lot of the talent are now pursuing freelancers model. How would your own employment contract in that specific market's labor law could support for that, right? Would that just a master template that fit for every market, or no? We have to tailor it market by market. So all this would require the management team to reconsider, right, the people that is going to govern this kind of, you might think it's a trivial matters, but it could come back and haunt you, right, if there's any issues arise. So thank you very much for today's invitation, and open for any questions if people have questions about this area.
Thank you very much, Ken. That's very, very interesting. Now, we have two perspectives now. The first, of course, in terms of trade. You know, the world, in fact, is full of closed doors if you want to trade with people. How do you open those doors? Now, what Ken has been saying is that, well, he has a lot of open doors, but when he enters those doors, in fact, he could be cheated. Somebody else actually is using his IP. Now, how do you deal with that? Of course, and the other question is that he has to manage the people who actually creates the IP for them. So these are interesting perspectives. Now, then we move to the next perspective, is that given these two situations, how would a finance person, in fact, deal with this? There are questions of taxation, there's question of corporate finance, question of investment. All of these, in fact, factor into this equation. And we have just the right person to talk to you, Robert Loy from Deloitte.
Thank you. And it's just, first of all, we'd like to let everybody knows that as a Deloitte, as an accountant, is that we meet a lot of clients every day, right, from different countries, from different sectors, like Ken, from media, Sunny from the textile. Sometimes we meet some tech guy, the microelectronics, and manage some like the AI, blockchain, cybersecurity as well. All these sectors will have some problem is that any sanctions behind any business partners or suppliers and the customers, what they are doing, the business is very important for the companies to consider before they are accepting being as their business partners. And as Deloitte, we are not only providing, say, the auditing services or accounting services to our clients. We will also have some services to them is related to the tax and also what I mentioned, some consulting services or even some like the risk services, like the assurance and also some the corporate finance services. All these kind of professional services. Of course, there's some legal services as well. We love to work with the lawyers because every time we get some legal opinions from them before we can and draw conclusions on the audit opinion as well. So what I like to share with all of you guys is that first of all, the boss were asking about is the financial reportings for the listed companies. The regulators and also the bankers, they always request about the financial statement, the audited financial statements. A lot of the financial disclosures, you need to make it on the financial statements, right? For example, if this is related to the sanctions, related to your customers or the suppliers, you have to disclose whether there is any potential risk of these sanctions. You have to fully compile what the accounting standards or the regulators require to disclose. Of course, we have to seek the opinion from the lawyers as well. So after this kind of disclosures, the bankers, the tax authorities will also request further information. For example, you have made some bonds or some fundraising or some bank loans. They will ask you about the cash flow. The bank is very concerned about the cash flow. Whether these sanctions will have a significant impact on your revenue. And also this kind of revenue, we are talking about the revenue recognitions as well, right? We have a lot of contractual obligations like the customers and the suppliers' contracts. Whether these sanctions will have an impact on your, say, maybe the first 2 years or you have a 5 years contract with these customers. Any impact on the revenue recognitions, any restrictions on these, say, the imports of your raw materials that will seriously impact your productions and your financial forecast, your revenue forecast, and your profit forecast will have some negative impact. So if this has impact on your financial, that is your cash flow or profitability, the banks have a very, very concern here that your facilities line, your bank loans, there is a question mark here. And if this is the bank loans, you have really the banks is no more bank loans granted to you, you have the liquidity problems, and maybe there is some more very important problem behind this as a bankruptcy or liquidations as well. So this is a problem about the disclosures. What kind of disclosures you have to make in relation to the sanctions? And the second part is that we noted that our clients have incurred a lot of costs if there is some business related to the sanctions, like the how to screening the contracts, how to got some legal opinions, whether the business partners, like the not only on your customers, maybe your suppliers that they will see through the transactions. Your suppliers, what kind of suppliers you got the raw materials from another suppliers, that is a series of change from the supply side. If there is any one of your suppliers that's have got sanctions, that may serious impact on your own business too. So we always advise our global clients that we need to know what kind of the sanctions and also any specific rules is related to your business sectors. For example, the sanctions is made on maybe to 1 year or 2 years, but of course it's drill into the details. Maybe you get some exemptions from these sanctions as well. So this is also very important things that we need to consider. And also, I think the shareholders, the board is very concerned is about the tax, right? We are redoing the global business. We're talking about the transfer pricing, all right? We have a lot of transactions between our intergroup companies, like your holding companies is in US, in Cambodia, is subsidiaries, in China, or in Southeast Asia. All these intercompany transactions may arise as the tax issues. The next part is that about the withholding tax, right? When you have some intercompany transactions, with another issue is that they withhold your profit and your tax. If there is any sanctions behind, how we can deal with this withholding tax, and also the tax authorities, whether there is any impose, like what Sunny mentioned is about the quota that we talked before, is that the factory processings, we are very careful. We set up with different subsidiaries or in different jurisdictions, a factory in different jurisdictions. The tax authority or even the regulators will ask about the rationale behind. We should have some the commercial substance, right? Sometimes we will see about the substance over form, whether your structure is mainly, for example, is tax planning, or even is more aggressive, the tax evasion. So because of these sanctions, the shareholders of the listed companies, or even for your own business, you need to think a lot of plan whether your business can go on. So what the professional parties like Deloitte is now, we need to advise the clients the potential risk. We need to not just there is a sanction risk and then we just skip the business or we just surrender. No, we need to manage the risk. How we can have a better planning if there is something happens, how we can manage is that. And what I mentioned before is that the second part is talking about the cybersecurity. The cybersecurity is also very important because every company now is talking about whether there is any hackers, what your business is doing, if there is any hackers in your business, or your data leakage, how you have the customer privacy, how to protect your data. Why I'm talking about the cybersecurity is that try to think ahead is that if your cybersecurity providers the knowledge or the domain or what you can think that is, let's say, is based in mainland or based in US, based in China, the countries will ask you a question is that you're being sanctioned is that what your suppliers of this cybersecurity is behind. And it is very significant is that these cybersecurity service provider, they can access a lot of your data because they provide some protection, like you have say, adopt the AI, a lot of the blockchain. All the data is behind, they can get it from your server. So if you choose your cybersecurity provider is in a country is being sanctioned or being have the potential being sanctioned, you need to pay very care attention here, whether we have to have a plan A, plan B, or your subsidiary A, subsidiary B have different kinds of service provider to handle this cybersecurity risk. So all in all, we're back to that is internal control, right? The board of directors, they need to consider everything is as a package. The cybersecurity, your business partners, your revenue recognitions. And the last part is that it's very important is about the impairment of your assets, right? If you have the sanctions behind, and finally, which is affect your profitability and your cash flow, and then your assets, like what Ken mentioned is that you may have some intangible assets, like your trademark, patents, or even your factory have the fixed assets. If your company is being a non-profitable companies, and then the accountants will ask you to make some impairment on your assets. If there is an impairment on your assets, finally, that's just the stock price will drop a lot, and maybe you will lose your listing status as a company is being listed on the stock exchange. Because I know I only have 10 minutes, I'm happy to share more accounting issues or financial issues in the Q&A sections. Thank you so much.
Thank you very much, Robert. Again, you see this third perspective. You have Sunny and Ken, who are both operators of businesses. And really, as a business, you actually have to look at your sanctions risk and how do you deal with that. But the thing which is encouraging to me is that the three speakers have all mentioned the use of lawyers. And I'm very glad I chose the right profession as a lawyer. Many of you are lawyers as well. But we have a real lawyer. I'm not a real lawyer in terms of sanctions. The real lawyer here is Minnie, and she's going to talk about sanctions.
Thank you. First of all, I'm really honored to join this distinguished panel speakers. And also, thanks a lot to all the other speakers mentioning about the importance of law and legal support. So I sit in the financial services team of King & Wood Mallesons in Hong Kong. And in our day-to-day practice, we act for a lot of international banks, domestic banks, Chinese banks, and also global companies with operations in China and Hong Kong. So, unlike the other angles, I'll focus back to the basics about the legal positions. So, sanction itself are highly complex. It involves multiple jurisdictions. You could already get a good sense that the complications that is not something that you could really work with a single team of lawyers to give you, sufficient insights to address the risk associated with the sanctions. But given that we are in Hong Kong, and I know that we've got a lot of visitors from overseas, so I do want to share with you the very quick overview about the Hong Kong sanctions regime. And then I'll talk about the more recent foreign sanctions which have a material impact on the Hong Kong business and also peoples around doing business in Hong Kong and China. And lastly, hopefully we will have time to talk about what are the, I'm not sure whether we can say that it's mitigants, factors, considerations, and lastly, what are the opportunities for us in Hong Kong. So, sanctions regime in Hong Kong. Hong Kong, for those who don't know much about Hong Kong, we are a special administrative region of China. And we are pursuant to the constitution, the basic law for Hong Kong. Hong Kong is, does not adopt autonomous sanction regime. And importantly, Hong Kong does not implement unilateral sanctions. You could imagine that for all foreign affairs, foreign jurisdictional affairs, it will fall within the ambit of the Central People's Government of China. However, we do have two local legislations which effectively implements only the United Nations Security Council sanction regime. And in the slide, which hopefully you will have a copy later on, these are the two ordinances, the United Nations Sanctions Ordinance, as well as the United Nations Anti-Terrorism Measures Ordinance. Important message to take away about Hong Kong is that Hong Kong only implements sanctions imposed by the UNSC, Security Council, to the extent that they are against persons and places outside China, because we are part of China. You will never implement a sanction against your own country, your own people. We do have other supplemental legislations. Again, I think in the interest of time, I'm not going to go through in details, but we do have multiple government agencies providing very useful information for the public to have a good know-how access to the sanctions regimes implemented in Hong Kong, and also the list of sanctioned countries pursuant to the UNSC regime. And these agencies spread across different government departments as well as the financial regulators in Hong Kong. Here again, it just provides you with some handy list hyperlinks. If you do have interest to know more about the sanctions regime in Hong Kong, and our firm has published quite a lot of sanctions-related articles, in particularly relating to the Trump executive orders, which have starting to have a lot of impact. Because Hong Kong, as an international financial center, we have most of the international banks operating in Hong Kong. So actually, 3 years ago, when Trump announced sanction orders against a list of PLC communist Chinese companies pursuant to and put them onto the SDN list, that have created a lot of impact for people who are dealing in securities relating to those underlying. Because for the industry, for the financial market, quite a few of those names are actually constituent stocks of the Hang Seng Index in Hong Kong. And a few years ago, we had to deal with, we have to act for some of the banks in winding down their positions because of the US sanctions. Even though I said that US sanction does not form part of Hong Kong law, but there are other factors which effectively render people operating in Hong Kong will have to still, adopt compliance program to observe and keep monitoring the situations. So the next one is a very, very high level talk about the recent sanctions. So I mentioned briefly the Trump's order targeted at some listed PLC Chinese companies. That is pursuant to the US sanction. But I think last year we see the overwhelming, widespread, and very, very broad scope of sanctions imposed by multiple governments across the globe against Russia because of the Ukraine war. And if you look at the scale and the scope, it's unprecedented in terms of the scope of sanctions and also the number of countries imposing the wide-ranging type of sanctions, ranging from financial sector to all the other sectors such as the energy sector, aviation sector, luxury goods, terrorists, and other sectors. But I think what I'm going to say about the Russian sanctions is that although you will think that I may not necessarily deal with the Russian directly, however, if you look at your supply chain, as Robert and all the others have mentioned, because of your global nature of the operations in Hong Kong, it's hard to tell whether somewhere within the supply chain there is some Russian nexus. And the important thing to understand is that even if your specific contract or transaction does not fall squarely into the sanctioned restrictions, but if you think about, can I still obtain insurance cover for my contract? Also, can I get payment through, to the extent there are some connections to the Russian payment system? These are all very, very direct and material question you need to ask for yourself. And more importantly, I think as a international financial center in Hong Kong, it's quite important to highlight the SWIFT ban, as a result of the Russian sanctions. So quite a number of Russian banks, they were disconnected from the SWIFT system, which is a internationally secure financial messaging system, effectively allowing global banks to facilitate cross-border payment remittance within the banking industry. And the SWIFT ban has a profound impact, although it doesn't really, you say that it's disconnecting to Russia, but it prompted a lot of thinking as to what if a country beyond Russia is put on, similar prohibition and got disconnected. And if you look at the SWIFT membership, they have over 11,000 participants. And there are over 600 PLC banks connected to SWIFT still. And so the issue is, although the Russian sanctions are adopted in the US, in the EU, in the UK, they do not form part of Hong Kong law. But because of the banking system, the SWIFT ban, we do have, in your day-to-day operation, you need to bank with different banks. And the banks, they are subject to, global compliance regime, including they need to observe a lot of the US sanction because of the connections to the SWIFT. So I think the SWIFT ban does impose significance or reflection about individual countries' contingency thinking in response to the SWIFT ban. So what are the key considerations that you may consider in addressing the sanctions issue? As I mentioned, I think the sanctions regime involve multi-jurisdictional, highly complex, and even for international legal firm like us, we have to have multiple sanction specialist team located in different jurisdictions that we operate. So whenever you onboard a new client, a new matter, you need to conduct a very thorough assessment about the potential nexus. You need to ask yourself whether there's any indicators about nexus to the sanctioned countries, sanctioned persons, and you need to go through screening process about your counterparty, the ownership chain, who are in control of your counterparty. And you need to do due diligence on your counterparty, your supply chain, as all the other speakers have mentioned. And very importantly, you need to reassess your contractual arrangement to see whether you've got contractual terms that enable yourself to early terminate. If for whatever reason you are restricted by sanctions regime to not able to continue the performance of your contract. So all these means that you need to have a very comprehensive compliance impact program to help yourself in providing your ongoing support for your clients, for your own company, and also to protect your staff as well, because they may be also impacted. And I mentioned about the significance of SWIFT and the SWIFT ban. And the good news, well, the positive side is for China, we do have a RCEP system, which is the cross-border interbank cross-payment system launched by the PBOC back in 2015. And the good news, I do notice that 2 years ago, I think the participant number was about 1,000 or so. And now I checked just over 1,000. And I checked again, I think yesterday on the RCEP's website, it appears that the participant number had reached over 1,400. So quite sort of a significant increase in number. And also it's quite interesting news that Standard Chartered Bank has been the first foreign bank direct participant in RCEPs, and they have effected the first cross-border direct renminbi settlement using the RCEP system. Further alternatives are central banks, digital currencies, and PBOC, as reported in news, have been working closely with a number of South Asian countries' central banks to have a direct clearing and settlement arrangement using central banks' digital currency, a project widely reported as the Project Enbridge. And we do look forward to further growth of the project. And I'm conscious of time. Finally, I think leave us some sort of a positive point for discussions is what is the role for Hong Kong? And Hong Kong as an international financial center is quite important that we continue to play this role. We continue to provide a infrastructure that could support, enable banks, financial institutions, businesses who are setting up and operating in Hong Kong feel comfortable that you are able to respond, to have a infrastructure that enable you to provide your services. And I think the particular strength of Hong Kong is the largest offshore renminbi center for China, and Hong Kong does not impose capital control, so we will play a very unique connector, super connector into China and to the world. And I think there are a few other points, but I think I'll leave it there and allow more time for our speakers and also Tony to share further discussions with the audience. Thank you.
Well, thank you very much indeed. There are a couple of points that I thought I'd just try to make clear. There are some acronyms that's been used. Now, the SDN list, this is a specially designated national list, which is used by the Office of Foreign Asset Control in the US Treasury. These are specially designated individuals or entities that the US wants to sanction. So when you call a guy in an SDN list, basically he's in that list, and if you're a US entity, you cannot deal with that person under the executive order. If you do, you're subject to criminal and civil penalties. The other thing which Minnie's been talking about is, if you're not in the SDN list, you're not dealing with a sanction, why on earth have you to be careful? Well, you have to be careful because under all the executive orders in relation to sanctions, there is one clause which says that anybody who gives substantial assistance to a person who is sanctioned, in fact, could be the subject matter of a sanction. And therefore, this is the secondary sanction, which everybody is very scared of, which is why when she onboards everybody, she has to be so careful so that she cannot actually get into a secondary sanction position. The third acronym is SWIFT. Now, SWIFT is actually called the Society of Worldwide, Financial Transactions. Now, it's an organization which is based in Belgium. Its shareholders are all banks, incidentally, financial institutions. In fact, the board of director of SWIFT, in fact, has got 20 people around the world. In fact, they're all bankers. But then, of course, they don't really control SWIFT at the end of the day, even as a board of directors. It's really the European Commission which actually controls SWIFT by way of its laws and its directives. And the Russian sanction in SWIFT was actually imposed by the European community, by the EU. Actually, it's not by the US, it's actually by the EU, because it's a Belgium entity. So therefore, this is the issue which is placed before us. Now, we have 15 minutes or so for questions and for discussion between us. But I'm going to let the audience go first. Now, if one of the okay, Nick, go ahead. Get the microphone, and please have the microphone ready. You raise your hand, and then the microphone will be brought to you. Nick.
Thank you, Tony. Question is, on sanctions, secondary sanctions, how should arbitrators or deal with this, or arbitration centers handle sanctions-related matters?
It's a very interesting question, isn't it? Because now, well, actually, I have an example. In fact, one of my members of a chamber is actually on the SDN list. A member of my chambers, actually, who was a very well-known lawyer and a former government official, senior government official. So if you were to ask a member of my chambers who's on the SDN list, let me ask your client actually wants to have her advise you or advise on a matter and so on, barristers. How would you react, Minnie?
I think, first of all, it's similar to us law firm who, take on a case. We do need to do some ring fencing. I think, well, first of all, sanctions doesn't mean that everything related to the names or the country or sectors are prohibited. I think the first question is we do need to make an assessment as to whether the proposed acts or dealing actually fall within the prohibition. We learned this from 3 years ago when Trump order announced about, against those Chinese companies. Everything suddenly thinks that, I can no longer deal with those companies put on the SDN list. But actually, it's not exactly the case because sanctions have many types of sanctions. And taking that example is about restrictions for U.S. persons, primarily to acquire, to continue to hold securities related or issued by the relevant SDN listed companies. And for those secondary sanction persons to facilitate that sort of dealing. So I think the first question always is to do a thorough analysis as to whether the act itself is sanctioned. And we do provide advice to our clients involving Russian sanction because, providing legal advice is not necessarily restricted. Yeah, so I think that will be the first thing we'll need to consider. And also, I think, secondly, is the personnel that get involved in dealing with the case. Obviously, sanction regimes evolve all the time. And sometimes it's hard for you to predict who might be put onto the list or expanded pursuant to the OFAC announcement. So what we do as a risk mitigation measure is we do have ring fencing arrangement within the organization structure. And I also noticed that for a lot of global banks, they have ring fencing for, say, staffs who hold US nationality, staff who hold other nationality, to be ring-fenced from dealing with not the sanctioned activity, but to be involved in any matters that have some sort of an nexus, even if it's not, as of today, prohibited under the sanctions. Tony, not sure whether that's...
No, that's exactly. I can tell you that my colleague who is on the SDN list has no shortage of work. She is employed very full-time and more than she can handle. So therefore, really, this is not an issue, mainly because the other firms which, of course, employ her to do work, essentially not within the SDN regime. American law firms would find it very difficult to do that because they are directly within the SDN regime. But non-American Chinese law firms, for example, is not within it. So my colleague has plenty of work, and not to worry on this. Let's go to the next question. Any questions from anybody? Well, okay, go ahead. Please announce your name and then your question.
Bill Amos, independent arbitrator.
Phil, good morning.
Bill, a question for the panel. Are you seeing a move away from the US dollar in the transactions that your companies are dealing with?
Interesting question. I think each of you would have an answer to that. I also have an answer to that as well. But let's start with Sunny. You're in the market. What's the position?
I think at this moment, it's primarily still on the US dollar because in, let's say, again, textile, apparel, or general light industry, consumer products, consumer goods, it's all dictated by the importing country. So the purchasing power. So it is more like the US or the crowd among the US community. And another thing is US dollar is a lot more stable. When we want to do certain financial hedging, you want to deal with your material purchase. Because the worst thing is you accept a purchase order in US dollar, but then when I need to make my purchase of my own material, it becomes another currency. And given at this moment, when your currency goes up and down, the factory will take on that currency risk. And that is not what we meant to be, because what we want to do is just to get a very small margin out from a production. And so we need to be very careful in hedging. So US dollar is still more stable. Having said that, similar to the banking clearing system, for our mainland Chinese business, that we are seeing more that we are looking into the RMB denomination. We are getting our purchase order in that local currency, and the amount is bigger and bigger. And also nowadays, when we are purchasing our material, we are buying it from China. So again, it's a natural hedge. So it's a lot easier also for us when we're doing business in China. We do it in RMB. So I think that is, as I said, we need to live within the sanctioned world right now. And being as a business person, we just got to be flexible and to be able to manage the risk. And FX is part of the risk. I hope I'm able to answer your question.
Let me ask Ken, because he's also in the market, and obviously, a lot of dollars or money comes through. What's the position, Ken?
I think for our business, spanning across 31 countries, so basically most are definitely still in USD, right? But basically we reserve multiple local currencies to support their operating expenses, right, on a daily basis. So what we are doing is we monitor on a quarterly basis, right, about the cash position, about the FX, etc. But I think nonetheless, as Cindy mentioned, I think US dollar is still the dominant force by now. So I don't see for our recipient, no matter the clients, the talents in terms of labor force, they will change from one currency to another in the near future.
Anything you can add, Robert or Minnie, in terms of the use of US dollar?
Not for my firm, but from the sector, I do think that it's sector dependent. For example, in the commodity sector, we do see a shift in regionalized, fragmentizing the commodity trading, currency, obviously because of the Russian sanctions. Yeah.
And for me, it is a very interesting and important topic because when we're talking about our clients, the clients are just thinking about whether they still should be use US dollars as is still dominant in the markets. But a lot of the board of directors, they raise the question is that whether they need to have a another plan to plan ahead if there is any the sanctions happen, what they need to do. And we see that what Sunny mentioned is that some hatching, they're using some financial products to how to de-risk, how to manage the risk properly from the US dollars and maybe renminbi. But the most important thing is that just depends on your main revenue stream. Whether your business partner, the main revenue stream is more international in US or in Europe based, if more in, I can say from this Asia countries, Southeast Asia in the mainland, the concerns of this using US dollars is a little bit less, but all in all, this is the factors is that the chairman or the board of directors, they will plan ahead how to manage back their currencies. But I just discussed with Minnie before, I said we will also consider about stablecoin as well. That's just our future that we need to consider a lot of things.
In terms of information sources, there are 4 sources. The first source is actually the IMF website. If you go to the IMF website, you'll see, in fact, that the world's reserve currency, in terms of reserve currency held by central banks, the US dollar has now dropped to slightly under 59%. It used to be, in fact, as much as 72% of central bank reserves. So now it's a little bit under 59%. The next announcement from the IMF will come probably in March next year, so we would know a bit more. But at the moment, it's a little bit under 59%. The second source is the SWIFT source. Now, SWIFT actually announces on a quarterly basis the amount of currencies that are used in world trade financing. In terms of world trade financing, the Chinese renminbi has now climbed to something like about 8%. But the US dollar is as much as over 70%. It's actually 78% or something like that. So basically, the US dollar is still the dominant world trading currency. The third source is actually in terms of direct, almost like barter trade on very large commodity deals between countries. For example, oil is one of those. In terms of oil, now, in fact, some major oil transactions are done through renminbi, but the renminbi is swapped through central banks. So therefore, these monies don't go through SWIFT. Basically, they go through basically bank accounts as well as central bank settlements. The fourth area is actually people with Bitcoin and stable coins and so on. We don't have statistics on that. But actually, a lot of anecdotes at the moment, Bitcoin particularly, or Ethereum. Now, you don't go to Italy to buy it. You go to Dubai to buy it, basically. And then you either pay ruble to somebody, and that guy would then use this to buy some Bitcoin and pay the dealer, basically. So there's a lot of sort of, you might say, sanctions, countermeasures, you might say, in terms of just happening at the moment. But a lot of countermeasures, which is very, very interesting. Now, we have about like 2 or 3 minutes. And I thought that I'd ask each of our unless there's one further question, I can take one further question if there's any. Now, okay, if not, then I ask each of our panel members to use a minute or so to really summarize their thoughts in terms of sanctions and in terms of supply chain. I'm going to ask in the same order. I'll ask Sunny first, and then Ken, and so on. Yeah.
Thank you. Like what I said, sanctions is something that we have to live with. So we got to be very smart to listen to our advisors, consultants, meaning that our legal advice and like Deloitte on the financial services, because it's going to hurt us if we do it without knowing it, because the risk has been much higher than what we can expect, and plan it accordingly. And there's not much that we can do because these are really G2G situations. However, when we are dealing with our customers, when we're dealing with suppliers, we got to be smart enough to de-risk, and sometimes your counterpart may not knowing it, so you will ending up getting certain advantage out of it. And for going into legal action, I don't think it's something that we want to do. Arbitration definitely is something that we should be going through if there's any dispute, because time is very important in business. So when we as a business person wanting to conduct a business, we better also think of it in the context of sanction. And how do we resolve any potential legal disagreement? I think if we can put all these things into perspective, I think for us when doing business, it will be a lot more effective and efficient, and I think arbitration would be important to us. Thank you.
Thank you. Even lawyers agree with you on this. Ken?
Yeah, I think it's very important to having two principles in place. One is crisis management, right? It would happen every day, no matter that's a governmental, political, new measure, or there's a firefighting mode that different parties are being bad actors to infringe about you. So I think it's more important how the company have a control mechanism in place, and you act upon different scenarios, right? So you should plan ahead instead of being panicked and being reactive. So I think that is very important. And second is while your business is going to be more global, right? How you are dealing with different suppliers and talents, right? This is also very important to bear in mind the different regulations. Number one is definitely different to what you are familiar with the local market. So finding advisor that also have a global presence would be very helpful to guide you through the first journey of integration or business expansion.
Proactive and planning ahead, very important. Robert?
Yes, I think every speakers have shared a lot of valuable views for you. Just for as a professional services firm, we are just talking about always talking about the risk. So the point here is the sanction risk, how we can manage the risk. So to manage the risk, I can share is that I see some of our clients is that they set up its own, say the sanction task group. Because no individual team can handle all these complicated issues. The task group may involve some members from the HR, from the supply departments, and also customers, and also, for example, that you need to have some expert here, and then to think ahead how to plan if the sanctions is here, and sometimes we need to seek some professional advice from lawyers, accountants as well. So we just how to manage it properly, because we need to live with the sanctions together, like just Sunny mentioned.
Thank you very much, Robert. Take professional advice, very important. Another professional.
10 years ago, I don't think I need to have a good sense of what are the sanctions regime in other countries. But I think these days, if you practice in Hong Kong, you cannot live without a general. No one can be a specialist, because I think it is a very complicated area. And you do need to have a local expertise to provide you accurate advice on the specific issues. But the important thing is we do need to be aware of the nexus, aware of the potential issues in your day-to-day practice. So not just about sanctions, but about money laundering. So all these become part of our lawyer's life that you cannot live away. And you do need to have a good sense, even though you are not yourself a sanction specialist.
Thank you very much, Minnie. I'm sure you will all agree with me that we've had a wonderful panel who's given us wonderful information. And may I suggest that we all thank them in the usual way. Thank you.
And also our wonderful moderator too. Thank you so much. So may I invite you all, please proceed in front of the stage and then photo together.
Thank you.
Please remain on stage. To express our gratitude, we have a souvenir for you all. It is a tote bag with some souvenirs inside. It is a Hong Kong style notebook bag and also a travel adapter. Hope you will always think of AALCO all the time when you travel. Thank you so much. Thank you very much. Once again, big hands to our guests. Thank you. Hello everyone, we have now come to the end of the morning section. We are now taking a lunch break and then please enjoy the lunch in the room S423 and S424. Please follow the way by direction by our staff. It is just the room next to the foyer. For the online participants, please use the same live streaming link and then we will see you again 2 p.m. 2 p.m. Thank you. gentlemen, our forum will resume very soon. May I now invite you all, please be seated. I would like to invite you all to sit closer in front of the stage, then you can have a more closer interaction with our speakers. Oh, ladies and gentlemen, our forum will be start now. May I invite you all, please be seated. In order to have the best environment, please turn your mobile phone to silent mode. Thank you. Honorable guests, ladies and gentlemen, welcome back to the Asian African Legal Consultative Organization Annual Arbitration Forum 2023. Today, we're going to have the last section. The panel session will be talk about dispute resolution in Asia and Africa, the way forward. So now we are going to have our panel discussion. May I invite you all, please be seated because we are going to have something big on stage. 请各位就坐，我们很快有很精彩的分享。So now, Just a warm reminder, if you have any questions to our speakers, please scan the Q&A QR code on your table and leave questions to our speakers. The participants joined by Zoom can submit your questions in the Q&A box during or after the presentations. So now, please join me in welcoming the moderator of this section, Mr. Clifford Tiverest, Principal Government Counsel, the Government of the Hong Kong Special Administrative Region of the People's Republic of China. Thank you so much. And also, we would like to invite the foreign speakers to join us. Mr. C.M. Chan, President, the Law Society of Hong Kong. Mr. Chan, please. Dr. Gaston Kenrick Duashley, Magistrate and Director, Legislation at the Ministry of Justice in Cameroon, President, African Arbitration Association. Mr. Jose Antonio Morilet, SC, Vice Chairman, Hong Kong Bar Association. Mr. Hun Wang, SBS BBS JP, Executive Chairman, South China International Arbitration Center, Hong Kong. So now, moderated speakers, the floor is yours. Please be seated. Thank you very much.
Thank you, MC, for the kind introduction. So good afternoon, everyone. Welcome you all to this final session of the AALCO Annual Arbitration Forum 2023. I'm honored to be here moderating this session with my learned fellow panelists. So the theme of this year's forum is resolving the differences in a changing world by staying true to the Bandan spirit. Now, the theme of this particular session is dispute resolution in Asia and Africa, the way forward. Now, there are three aspects to it. To provide an overview of the trends and new developments in arbitration, mediation, and adjudication in Asia and Africa, to explore further what should be done by the international communities, local governments, arbitration institutions, and professional bodies to maintain the healthy and robust development of the ecosystem for dispute resolution in the Asia-Africa region, and lastly, to address the capacity building of arbitration talents in Asia and Africa. Now, I think one can immediately see that the program is carefully designed in such a way that this session is given the particular theme, as I just mentioned. And one should bear in mind the Bandan spirit in examining those three aspects. Of course, the Bandan spirit comprises 10 principles, reflecting a sense of common purpose and solidarity. I believe the last three principles are particularly relevant to our session. The principle 8 is settlement of all international disputes by peaceful means, such as negotiation, conciliation, arbitration, or judicial settlement, as well as other peaceful means of the parties' own choice, in conformity with the Charter of the United Nations. Principle 9, promotion of mutual interests and cooperation. Principle 10, respect for justice and international obligations. So as I see it, this panel is essentially tasked to look at two major questions. In terms of resolving differences, where are we now, and where do we go from here? Against the background that we are living in a changing world, in a post-pandemic era, in an age of e-commerce with advanced technological developments, particularly artificial intelligence, with emerging issues like ESG concerns. Now, all these present challenges, but also opportunities. We're honored to have four distinguished speakers here today with us discussing these issues together. Each panelist will first make a short presentation. We will then have a panel discussion, and there will be a short Q&A session towards the end. So without further ado, may I introduce our first speaker, Dr. Gaston Kenrick Duashley, who will be sharing his views from the Africa's perspective for the next 20 minutes. Dr. Duashley is a magistrate in Cameroon. He is the Director of Legislation at the Ministry of Justice in Cameroon. He is also the President of the African Arbitration Association. He has a wealth of experience in acting as sole arbitrator, co-arbitrator, mediator, and conciliator, both at the domestic and international levels. In particular, he is registered on the list of arbitrators and conciliators at the International Center for Settlement of Investment Disputes, the Organization for Harmonization in Africa of Business Law, Common Court of Justice and Arbitration, and is a member of the Permanent Court of Arbitration. Dr. Dwashni, please. Thank you.
Thank you, Mr. Moderator, to give me the floor. I have to speak on 2 points. The first one will be on the new configuration of the Common Court of Justice and arbitration system. And the Common Court of Justice and Arbitration, I will use the acronym CCGA. And on the second part, I will have to talk about the immunity from execution in the OHADA space, from the forceful execution to the peaceful execution of this principle in the OHADA space. First, the new configuration of the CCGA arbitration system. Yesterday, when I was presenting the OHADA institutions, I mentioned the Common Court of Justice and Arbitration, and I told you that it was the Supreme Court of the OHADA contracting state in OHADA business law, but at the same time, an international center of arbitration modeled on the ICC Court of Arbitration. I want to focus today on its arbitration function. And in this regard, I will say that the former international rule concerning the arbitral function of the CCGA provided that, and I quote, the Common Court of Justice and Arbitration intervening in arbitration matters is composed of the chairman, 2 vice chairmen, and the judges. It shall be assisted in its work by a general secretary. The Common Court of Justice and Arbitration shall sit either in plenary session or in restricted formation, end of quotation. So, in its arbitration function, the CCJA was composed of its own judge. In other words, the CCJA system of arbitration, being an institutional system of arbitration, was administered by its proper judge, you see? Whereas at the ICC Court of Arbitration, administration is not conducted by judges, but by lawyers specialized in ADR, you see? But the functioning of the CCJ with its judge administering his arbitral proceeding and at the same time being at the control of the CCJ award after the arbitration proceeding. This functioning gave rise to numerous and persistent criticism because it was not understandable that the same person administer arbitration, and at the end of the day, the same person are there for the control of the arbitration awards. So due to this critique, the court took into consideration this critique and decided to adopt new internal rules concerning arbitration matter. And last October, during the last meeting of the OHADA Council of Ministers, this council adopted a new regulation concerning internal rules of the CCJ in arbitration. And as from now, due to these new rules, there is a committee made up of lawyers specialized in ADR and they are dedicated to the administration of the CCGA proceedings. And the court now is only at the control. That is, the system of arbitration is administered by a body made up of the lawyers that are specialized in ADR, whereas the judicial control of this award will be made by the court in its jurisdictional function. And when I mean the control, when I talk about the control, I mean the request for exequatur and the request to set aside the award. Here, it is the court itself in its judicial function. And by doing so, the Common Court of Justice has decided that its institutional system of arbitration has from now function as it ought to function normally. That is, administration is made by a group of lawyers that are specialized on ADR, whereas the control is dedicated to the judge. They are specialized to judicial control because they are judge, and the judge, the state judge, we saw yesterday that the state judge have to cooperate to arbitration. So in the CCG arbitration system, the administration is made up by the lawyer specialized in ADR, whereas the control is made by the court in its jurisdictional function. This is the innovation I wanted to stress. But there is a specificity in the CCG arbitration. That is, his exequatur has a communitary character, which means that once the president of the court or the judge delegated by the court grant exequatur to the CCGA award, this makes the awards binding and overriding on the whole OADA space, whereas outside the space, the recognition of this award will be sought with the New York Convention, because outside the OADA space, OADA awards are foreign awards. Therefore, their recognition and enforcement will be sought in accordance with the New York Convention. These are the specificities I wanted to stress concerning OADA and the CCGA system of arbitration. With that, let me move to my second point that is dedicated to the immunity from execution of public legal person in the OADA space, from forceful to peaceful execution. In an article published in the Global Arbitration Review in 2020, I explained that the Uniform Act organizing simplified recovery procedures and enforcement measures contains an Article 30 which reads as follows, and I quote again: compulsory execution and protective measures shall not apply to persons who enjoy immunity from execution. However, any debt which is certain, due and owed by state corporation or firms, regardless of their legal form and mission, shall give rise to a set-off against debts which are also certain, due and owed them, subject to an agreement of reciprocity. The debt of state corporation and firms referred to in the proceedings paragraph may only be considered certain within the meaning of this article where they arise from either an acknowledgement by the said corporations and firms of the debts, or from a rate which is enforceable within the territory of the state where the corporation and firms are located. End of quotation. It is interesting to note that after having those applied in absolute, the immunity from execution of public legal person has provided for by this Article 30. The Common Court of Justice and Arbitration began to evolve its case law on the issue. So, for example, in a ruling issued on the 26th of April 2018, in a case opposing an individual, Mr. Mbulu Muzeso, to a Congolese semi-public company called Grand Hotel du Congo, the Common Court of Justice and Arbitration decided that this public company has commercial activities, and that because of this, it cannot enjoy immunity from execution, even if the Democratic Republic of Congo is a state and has shares in these societies. The Common Court of Justice and Arbitration noted also that Grand Hotel du Congo is a public limited company whose capital is held in equal shares by private individuals and by the state of Congo and certain of its subdivisions. The court added that such a company, although a mixed company, a mixed economy company, remains a private law entity due to the commercial nature of its activities and is subject to enforcement on its own asset. The CCGA confirmed this case law in its judgment of 26 November 2020 in a case concerning Société Ivoirienne de Concept et de Gestion and the Ivorian branch of Banque Malienne de Solidarité. In this case, the CCGA began by noting that the Malian Bank and the Ivorian Bank of this and the Ivorian branch of this bank are first and foremost public limited companies governed by OHADA law on commercial companies. That such a company, including the one in which a state or a public legal person has a hold, is a partner, has commercial activities, and cannot enjoy immunity from execution. Now, the innovation came with the new Uniform Act on Recovery Update, adopted by the Council of Ministers, by the OHADA Council of Ministers during its last meeting in 16 on 17 of October 2023. With a view to updating this Uniform Act, which is the most dynamic text in the OHADA law, the OHADA legislator has introduced some interesting innovations, some of which concern immunity from execution of public legal persons. And in this particular point, the OHADA Council of Ministers has taken into consideration the evolution of the CCGA jurisprudence concerning the immunity from execution of the public legal person in the OHADA territory. So, Article 30 of this new text reads as in the former text, but it is accompanied by Article 30 sub 1, 30 sub 2, and 30 sub 3. Article 30 sub 3 reproduces the Vienna Convention on Diplomatic and Consular Immunities and does not call for any particular comment. For its part, Article 30 reaffirms, as in the past, the principle of immunity from execution of public legal persons, in particular the state, local authorities, and public establishments. It is specified, however, and this is the innovation, that any debt evidenced by an enforceable title or arising from an acknowledgement of debt by a public legal entity, that is, state, local authorities, or public establishment, may, after formal notice that has remained unsuccessful for 3 months, be automatically registered by the Minister of Finance in the budget of the legal entity in question as compulsory expenditure. I say it again. Any debt evidenced by an enforceable title or arising from an acknowledgement of debt by a public legal entity, that is, a state, local authorities, or public establishment, may, after formal notice, has remained unsuccessful for 3 months, be automatically registered by the Minister of Finance in the budget of the legal entity in question as compulsory expenditure. This is the new Article 30, sub 1. The fact that the creditor must refer the matter to the Minister of Finance for this purpose constitutes a guarantee, because by having the debt registered in the account and budget of the public legal person in question as compulsory expenditure, the Minister of Finance thus provides a kind of guarantee that the creditor will be paid. As a result, it appears that creditor will normally no longer need to practice forceful execution by the seizure of the asset belonging to the public legal person in the OHADA space. In other words, forceful execution will leave the place to peaceful execution, provided that the creditor knows how to be patient and perceptive. This is for Article 30, sub 1 of the new Uniform Act. And I think this is a very important innovation, because instead of looking for a seizure against a legal person, you just have to consolidate your title. You notified it to the Minister of Finance, and if after 3 months you don't have any reaction, this credit should be registered as in your budget. So there is no more need to make a seizure. You just notify your title. We wait for at least 3 months. You are patient, and then the credit is registered in the budget as compulsory expenses, and you'll be paid. I don't think with such a provision, the creditor needs to make seizure again. So this is an important innovation, and I thought I could share it with you. Thank you for your attention.
Thank you, Dr. Darshni. We'll follow up on that during our panel discussion.
Yeah. I'm available for discussion. Thank you.
Thank you. So let me now introduce the representatives from Hong Kong who will collectively share their views from the Asia's perspective for another 20 minutes or so. So first up, we'll have Mr. CM Chan talking to us about the importance of having an efficient and effective investor-state dispute resolution mechanism. CM is a seasoned solicitor. He has been the president of the Law Society of Hong Kong since 2021. He serves on a number of statutory bodies, including the Law Reform Commission. He is an external examiner of two of the law schools in Hong Kong, the Hong Kong U and the City U. He is also the head of the Center for the Rule of Law of local think tank Hong Kong Policy Research Institute. And then next we will have Mr. Jose Antonio Miralet, SC, who will be sharing with us how Hong Kong as an international arbitration hub is making good use of its strengths to contribute to the arbitration development in the region and beyond. Jose was appointed as senior counsel in 2016. He has been the vice chairman of the Hong Kong Bar Association since 2022. He has served in the same position from 2017 to 2020. He has sat as a deputy High Court judge between 2018 and 2021 and has been appointed as a recorder of the Court of First Instance since October 2021. He is a council member of the Hong Kong International Arbitration Center as well as a former member of its appointment committee. And then finally, Mr. Hyun Wong, SBS BBS JP, will be discussing two new specific developments on the arbitration front in Hong Kong. Hyun is a very experienced member of the legal profession. He is the executive chairman of the South China International Arbitration Center, Hong Kong, and the honorary chairman of the Hong Kong IAC. He is the past president of the Law Society of Hong Kong, the Hong Kong Institute of Arbitrators, as well as the Inter-Pacific Bar Association. He is currently chairing the Arbitration Committee of the Law Society and is also the honorary advisory of the Hong Kong Mediation Center. So without further ado, CM, the floor is yours. Thank you.
Good afternoon, ladies and gentlemen, distinguished guests. It is indeed my honor to be here this afternoon to share with you a few thoughts about, especially about investor state settlement mechanism. Like Clifford said, I'm wearing different hats, but I'm not officially representing the views of the Law Society today, so most of the contents are my personal views. So very quickly, 10 minutes, we'll be talking about Asian, African countries, because of the Belt and Road Initiative. It's actually very timely. This is the 10th anniversary of the Belt and Road Initiative. We have a lot of different forums about how the Belt and Road Initiative should go forward in the next 10 years. And no doubt, infrastructure, linkages, finance, politics, social, cultural, are all these part of the problems along the Belt and Road investments. So given the cross-border, multilateral, complex nature of Belt and Road Initiative projects, disputes are basically inevitable. And an effective dispute resolution mechanism is definitely called for in order to assist the relevant parties, be they private or public, to resolve the disputes of a commercial nature in an effective, timely, and economical manner. So I'll be focusing mainly on the investor-state disputes, namely disputes that involve a sovereign state. Dispute resolution could require special attention. In fact, this is actually very controversial. If we have time, we can talk a little bit more whether this is fair to domestic players. Generally speaking, although investor-state dispute is one of the specialized types of international commercial dispute, the general principles on dispute resolution still apply. So those principles which apply to resolution of private disputes may be of equal relevancy and importance to dispute resolutions for international commercial disputes. So first off, let's take a look at a recent report by UNCITRAL, United Nations Commission on International Trade Law, Working Group 3. They published a paper in 2018, so 5 years ago. The paper basically identifies three main deficiencies or problems, 3 areas of concerns for investor-state arbitration under the Investor-State Dispute Settlement Mechanism, ISDS. First, lack of consistency. Lack of coherence, predictability, and correctness of arbitral decisions. Quite damning, actually, the wordings they use in the report. The working group found that inconsistencies could exist in the interpretations on substantive standards, jurisdiction, and admissibility and procedural matter. So that's the first concern. Second, the working group also raised concerns on whether there were effective safeguards to ensure that the appointed arbitrators could remain independent and impartial throughout arbitral process, and possessed the appropriate qualifications and characteristics to decide the case before them. Of course, arbiters are to be decided by parties. So they raised the second concern about their qualification, competency. The third concern the working group expressed is on the cost and duration of the arbitral process, which of course were affected by a number of elements such as quality of the factual records, ineffective case management, etc., etc. So these are concerns on the qualities of the arbitrators and the effectiveness of the process and the relevant procedures, including court proceedings, which actually can be illustrated in a very recent case, Nigeria and versus P&ID. A very recent case delivered only a few weeks ago. I'm not going to go into detail of the case, which basically is about a case decided by the Commercial Court in England in October this year. The case may or may not be appealed, I don't know, I haven't actually checked this morning. But so I'm not going to talk about the subject matter itself, but in essence, it's a Nigerian government and a BVI company. They enter into an agreement for a development project in 2010. Disputes subsequently arose between the parties as to whether there was underperformance of the work under the agreement. So the parties referred their disputes to arbitration, and the tribunal, the arbitration tribunal, was challenged, but was duly established in 2013. The tribunal published a partial award on liabilities and a final award on damages, respectively, in 2015 and 2017. So in summary, in short, the arbitration tribunal held that Nigeria had committed a repudiatory breach of the agreement of the parties, and Nigeria was liable in damages for an amount of no less than $6 billion owed to the parties. So it's a huge case. Nigeria challenged these awards before the Commercial Court in London on the basis of allegations of bribery, corruption, and perjury on the agreement and the arbitral process as a whole. The Commercial Court set aside the arbitral awards against Nigeria. At that time, the compounded interest exceeded $11 billion at the time of the judgment. But like I said, I'm not going to go into details of the case, but some very interesting quotes by the judge. Let me bear with me. I'm just going to read them out. So these are the exact quotes by the judge, the presiding judge. The case has shown examples where legal representatives did not do their work to the standard needed, where experts failed to do their work, and where politicians and civil servants failed to ensure that Nigeria as a state participated properly in the arbitration. Another quote, what is an arbitral tribunal to do? The tribunal in the present case allowed time where it felt it could and applied pressure where it felt it should. Perhaps some encouragement to better engagement can be seen as well. Yet there was not a fair fight. Could and should the tribunal have been more direct and interventionist when it was so clear throughout the arbitration that Nigeria's lawyers were not getting instructions? Should the tribunal have taken the initiative to encourage exploration of new bounds of contract law and the law of damages? There are other quotes, I'm not going to quote them, but quite damning, as you can see. So the comments by the presiding judge invite one's attention to the importance of at least the following points for investor-state disputes, in my view. Number one, competencies of the parties, their legal representatives and experts in such arbitration process. The readiness and willingness of arbitrators to be more direct and interventionist when there is a clear and significant imbalance of power between the parties. Third, the necessity of additional safeguards of some arbitration cases, if appropriate. For example, when an arbitration is involving a state or the amount of the case is large. So these are the gist of the case on the screen. So to me, there should be some reform resolutions to deal with the alleged problems. It is noticed that the global community is aiming for a completion of the overall reform of ISDS regime and a final adoption through the United Nations process in the near future. So as a result, it seems to me that continued discussions on this enhancement of arbitration and dispute resolution for international disputes are being called for. Just to conclude, I think these are some of the extracts. I forgot to turn the page. But anyway, the slides are available by the organizer if you want a copy of it. I think in conclusion, enhancement of arbitration and dispute resolution mechanism is certainly essential. And any proposals and recommendations thereon are needed in particular for the continued success of the Belt and Road Initiative and the fostering of international cooperation among Asian and African countries. I'm more than happy to share some more thoughts, especially the controversial part of investor-state disputes. Like I said, what's the impact on domestic players? So that's the end of my presentation. Thank you for your attention. Thank you.
Thank you, CM. Thank you. Thank you, CM. So, Jose, your turn, please. Thank you.
Ladies and gentlemen, good afternoon. I'll be presenting in the next few minutes essentially about why arbitrate in Hong Kong, since we're in Hong Kong, and explaining why Hong Kong is an ideal venue, an ideal seat to arbitrate. So I think you'll be familiar with the Queen Mary survey. It's been cited regularly in arbitration circles. We say we're in the top three. Basically, we're number 3. Now, the arbitration seat, when you pick it, inevitably it's linked to the legal system of that jurisdiction, because the courts of that jurisdiction will be the supervisory court. And as you know, it's important because if you're dealing with not just the arbitration, but the aftermath, in other words, leave to enforce, setting aside, and interim measures in between, it's very important what jurisdiction you pick. So the question is, well, why Hong Kong? Why are we number 3? Now, Hong Kong is the only common law jurisdiction in the People's Republic of China. We apply the common law. So essentially, in terms of substantive law, in particular, if you look at the commercial law, company law, it's 99% the same as it is in England, in Singapore, in Australia, or New Zealand. For historical reason, English and Chinese are the official languages in Hong Kong. So if we look at the latest World Justice Project Rule of Law Index, it gives us a number of interesting statistics. I think this one came about a month ago. It's for 2023. The overall ranking in terms of rule of law for Hong Kong, we were given 0.73, which is the same as France. In terms of absence of corruption, which I think is important not just for arbitration, but in other fields and spheres of commercial activity, we were given 9 out of 142 jurisdictions. For civil justice is free of corruption, we were ranked 6th in the world out of 142. For alternative dispute resolution mechanisms being accessible, impartial, effective, we were ranked 25th. And for civil justice overall, we were ranked 20th. Now, the arbitration ordinance, which is the main statute governing arbitration, it basically follows the UNCITRAL arbitration regime. We are, as you would expect, a member of the New York Convention. The Hong Kong judiciary is independent. Judges are essentially appointed from private practice, both the solicitor's branch, of which CM is the current president and Yuan was the former president, and barristers, because we have a split legal profession in Hong Kong, like in certain common law jurisdiction. Now, under the basic law, which is our effective constitution, there's actually no nationality requirement for judicial officers and judges, except for 2 senior judicial positions, namely the Chief Justice of the Court of Final Appeal and the Chief Judge of the High Court. I believe this is probably quite exceptional anywhere in the world. As a result of the resumption of sovereignty, all judges who were previously in office continued, and we have a very experienced and diverse judiciary. In fact, the judge in charge of competition matters, who previously was in charge of companies matters, was English, and so is our present judge in charge of the constitutional list, who in fact was a former chairman of the bar. At the same time, Yuan was president of the Law Society. It's Justice Coleman. The Apex Court, the Court of Final Appeal, which replaced the Privy Council upon the resumption of sovereignty, benefits from, in its constitution, one overseas non-permanent judge. Those are generally judges who have either sat at the highest court in their own home jurisdictions, such as England, Canada, or Australia, or at least were members of that court. So that ensures that Hong Kong jurisprudence in both commercial and non-commercial matters, including arbitration matters, benefits from it. And in fact, there's a recent Court of Final Appeal decision, which I don't have time to mention now, but that went all the way up to the Court of Final Appeal as well. Now, very few cases, of course, make it all the way to the Court of Final Appeal, and one hopes, especially if one is a litigant, that actually matters progress on quickly with minimal court involvement. But on the day-to-day basis, the court which will be most affecting litigants in arbitration would be the arbitration list, because Hong Kong has a dedicated construction and arbitration list judge, which is reputed and reputable. It is currently led by Madam Justice Mimi Chan, who previously was a litigation partner at the firm of Allen and Overy prior to her elevation to the bench. The word pro-arbitration is not just something that we at the bar, at the Law Society mention. It's actually referred to in many, many judgments. I'll quote from two brief quotes from judgments in a few minutes. But essentially, awards are almost always enforced and very rarely set aside. Like in most other jurisdictions now, you need a very high threshold before there's judicial intervention. Now, speed is also very important, and this is something which I think Hong Kong does quite well, which is that the judge in charge of the arbitration list is willing to deal with matters very quickly. Because, of course, at the end of the day, if you've got your award, you want to get your leave to enforce. And if somebody wants to set aside, you don't want this to be dragging it on. In 2016, her ladyship, in one of the first instance judgments, said this. She says, "It has been emphasized by the Hong Kong courts that the object of the arbitration ordinance is to facilitate the effective and speedy resolution of disputes by arbitration. And the primary aim of the courts is to facilitate the arbitral process and to assist with the enforcement of arbitration agreements and awards as mechanistically as possible. This, however, should not in any way be seen to undermine the importance of due and fair process and the fundamental safeguards which must be observed to ensure that no injustice arises out of the arbitral process or the award." Ms. Justice Lam, who was then Vice President of the Court of Appeal, now on our Court of Final Appeal, said this when he was in the Court of Appeal. He said, "The underlying philosophy in respect of the limited role of the courts in respect of enforcement of arbitral awards is that parties who have undergone arbitration should have finality as speedily as possible and with as little expense as possible." So this is plainly pro-arbitration. Now this is the more sort of high stuff. In terms of the practical matters, why do it in Hong Kong? Why arbitrate in Hong Kong? Now first of all, who can represent you? Section 63 of the ordinance spells it out. Anybody. You don't have to instruct a lawyer, let alone a Hong Kong lawyer, be him a solicitor or barrister. Although in practice, you'll find that many, at least in that team, have, if not just a solicitor, will also have a solicitor and barrister, because of course the case may go on and you may need leave to enforce. There may be somebody who applies for leave to set aside. So that's quite common. But basically in any case which is of a certain size, you would expect Hong Kong solicitors and barristers to be part of that team. But of course, in many other cases, and the substantive law may be non-Hong Kong law, it may be other common law, it may be US law, or it could be mainland Chinese law, it could be German law. You often have foreign lawyers cooperating with local lawyers. And this is why the ecosystem is important. We're not a sort of a desert where you have to fly in everything. Essentially, you have more than 8,000 solicitors in private practice in Hong Kong who have a practicing certificate. We have over 1,600 barristers because Hong Kong has a split legal profession based on the English model. And most of the time, you find on the bigger cases, as mentioned, you've got Hong Kong solicitors and barristers together. We're not working as competitors, but in a symbiosis. Now, in Hong Kong, we also have registered foreign lawyers. So those are lawyers admitted in non-Hong Kong jurisdictions. It could be the US, it could be Cayman, it could be France, which is 21 registered foreign lawyers. And that, of course, is also a resource which is available to the litigants and to parties who want to arbitrate here. And I think it's important because it means you have that rich ecosystem to support the arbitral process. Hong Kong is an incredibly open legal market. We have these foreign lawyers who practice their home law, but it's also quite possible, in fact many have, from overseas jurisdiction, come to Hong Kong and become admitted either as Hong Kong solicitors or Hong Kong barristers. And I think if you look at the law list, or if you look at the bar list, there's actually quite a high percentage of people from all over the world. In fact, Singapore, which is spoken much about these days, especially comparing it with, one way or the other, with Hong Kong, you'll find that actually there are quite a lot of young Singaporeans who have chosen to, after graduating either from Singapore or British universities, to come to Hong Kong and practice at the bar, for example. So there's actually quite a rich choice for litigants to pick from. So that means it's multilingual. It means we have people from different skill set. And of course, it's not just lawyers, because as you know, dispute resolution, you need experts, and we have pretty much experts in every conceivable discipline, from handwriting to forensic accountants, etc., etc. And finally, and that's probably not an unimportant point, although it gets overlooked, is the question of visas. So in some jurisdictions, of course, if you have somebody who's an arbitrator or an advocate or an expert witness or even a witness, if he wants to come to your jurisdiction to work, to give evidence as an expert or as an advocate, it's quite complicated. Now, since the 29th of June 2022, Hong Kong has run a pilot scheme. It's called the Pilot Scheme on Facilitation of Persons Participating in Arbitration Proceedings in Hong Kong. So basically, the aim of it is to facilitate it, to make things quite seamless. So all in all, I mean, all of this, some of it you can find on the web, but I think the main point is it explains, I think in gist, why Hong Kong is such a popular seat for arbitration. Thank you very much.
Thank you, Jose. Thank you. So finally, Hyun, may I invite you to present your part? Thank you.
Right. Good afternoon, everybody. Nice to be able to say good afternoon to all of you. Because I paid a cheap ticket and they gave me a seat with restricted view and I can't see this part of the audience. You should have put Jose, who is 6 inches taller than I, to sit here. Sorry, no offense. Right then, I'm going to spend the next 7 minutes or so, 10 minutes, no more than, to talk about various, just 2 aspects of developments in relation to arbitration in Hong Kong, just to demonstrate that Hong Kong is always pro-arbitration, and we are doing everything we can to make sure that we maintain the status as the arbitration hub in the world, or at least one of the leading arbitration hubs in Hong Kong. First thing I want to talk about is the charging mechanism. Officer is nothing new. It started in various other jurisdictions, for example, in the UK. And then recently, this part of the world, Singapore and Hong Kong, and all talk about whether we should introduce officer, which is short for outcome-related fee structures for arbitration. You see, in Hong Kong, under the various code, the bar code, the law societies, conduct code, both used to restrict any form of charging your clients if it is related to the outcome of the case in a contentious matter, and that is strictly prohibited because I think in the old days under common law, they say that you being a lawyer, barrister, or solicitor alike, right, you should not have any personal interest in the legal matter which you're handling for your client. Right? That, I believe, is the spirit. So, so we have championed all these common law offenses. But then things have changed, of course. Then other jurisdiction has already introduced officer, and after several rounds of consultation in Hong Kong, we decided that we adopted, but only in relation to arbitration. And partly, well, mainly because if other jurisdictions allow officer in arbitration, we have to do the same. Otherwise, it will cause inconvenience to certain disputants. And so one of the, I think most of you will have heard of OFSA, and there's absolutely no place for me to explain details of OFSA scheme because it will take about 2 hours to finish. Shortly, it's just that there are three forms of charging mechanism, three new forms of charging mechanism you can now have. One is conditional fee agreement, CFA, the other is damages-based agreement, DBA, and the third one is a combination of the first two, i.e. hybrid damages-based agreement. To make it, to give a very simple, put it in the simplest form is that conditional fee, just, if you charge a client, if you win, then you get paid. No win, no pay. All right, this is a contingency arrangement, again, used to be disallowed, prohibited. Now we allow, but how much is all, well, there are minor details, but basically subject to the client and the lawyer's agreement. All right, if I win, I'll charge you that much. If you lose or you cannot win, I will charge less or even no money. Damages based is that I will charge you the amount of money according to money you received from the opposition on the losing side. So I will take a share of the damages, and that is damages related. And again, used to be strictly prohibited under the offense of championship and maintenance. And now the third type is hybrid. It's a bit of both. All right, I will charge you something anyway, but if I win, I'll charge more. If you lose, I'll charge less. But if you win, not only that I will charge you and charge you more, I will actually share part of the damages you received. So that's a hybrid. All right? Okay, as I say, I have no intention of going into full details. But then what I will say is that since the introduction of OFSA, and a few years ago, we have already allowed third-party funding in Hong Kong. That is to say, you do allow funder to come in to Hong Kong to fund arbitration cases to put over money for one of the disputants, right? And that now with the introduction of OFSA, actually Hong Kong allowed a combination of both. You can use both, right? You can use OFSA and you can also rely on third-party funder. That will make access to justice much easier in Hong Kong because a lot of time people will say that I do have a strong case against a giant company, but I really don't have the resources to challenge the mighty giant company. Right? Then, in a case like that, when it comes to arbitration, really you need OFSA and you need third-party funder. In order to accommodate that, the law has already been passed into full effect last year. And there are also rules, minor rules to look after the minor details. Everything is just now in place. Now, even the Hong Kong Bar Association has amended their code of conduct, paragraph 13A3, and the Law Society has also amended their guide to professional conduct. In fact, under principle 4.01, instead of the small prints, here is a commentary 18 they have just introduced. And our committee and the Law Society is studying the commentary and will be included in the new principle. Guide is the principle. You know, principle give you the principle. The commentary below, just like in the white book, they give you further details. Right? These very lengthy sentence basically say one thing. From now on, a client walks into your law office, needs your help, in addition to understanding the case and everything, explaining the case, the merits of the case, you need to explain to the client that there are different ways of charging, okay? OFSA or third party. That's basically what it says. Right, next, the way forward, with this, armed with these new charging mechanisms, and I think Hong Kong is much better placed to compete with other jurisdictions when it comes to arbitration. As to how popular OFSA will be, well, actually, third-party funding has been in Hong Kong for quite a while because third-party funding is actually was or has been allowed in certain insolvency matters already. So there's no stranger in Hong Kong. But when it comes to arbitration, just started, it's reasonably popular. Also, really early days, I've been told that there are already a few cases, but I'm sure I can carry them in one hand. But it's still early days. Let's find out. I am reasonably confident that it will be quite, become popular as the client need to know, right? And corporates must have tried it before they, it's word of mouth, right? People will have to recommend to other companies. All right, that's the part one I'm going to say. Now, as I say, I want to touch on two aspects of new developments in arbitration. And the one I've just finished is in form of legislation. The second one is a case law. It's a recent case. This case started in the arbitration, heard by the arbitrator, and then went up to the court the first instance before Judge Godfrey Lam. And then it went up to Court of Appeal with 3 judges, right? Then eventually went up to Court of Final Appeal. This case has seen 3 levels of courts in addition to the tribunal. So it's much awaited judgment. And now everybody want to look at this. You see, this one concerns a multi-tiered dispute resolution clauses. A multi-tiered dispute clauses there are a lot of nicknames for this type of clauses. Some people call them cascading clause, some of the waterfall clause. Anyway, I don't know why there's so many beautiful names. In short, basically the clause there is a series of alternative dispute resolution techniques: negotiation, mediation, arbitration. In the old days, you have mini trial, things like that. Multi-tier is that you are required to, or the parties are required to go through all the steps before reaching arbitration is the final step. And then the big question is, what if the parties missed one step? Will the arbitration still be valid? That was always the question. And so people argue, look at the quote, tribunal did not have jurisdiction to hear the dispute because the relevant agreement contained a condition precedent providing for mandatory negotiation which had not been satisfied. So there is always the bone of contention. Whenever you see a multi-tiered dispute resolution clause, this is a question people often ask, all right? So the tribunal says, sorry, you have no jurisdiction because in the arbitration agreement, there are different mandatory steps, and these steps have not been taken. So this type of multi-tiered dispute resolutions, people call it agreements to agree. There's so widely divided opinion. Some said, come on, this agreement to agree, this cannot be taken too serious. Others said, no, you take it very seriously. You see, in 30 years ago when we started doing business in mainland China, right, all joint venture agreements always start with the disputes arise. Both parties had to be use the most sincerity to try to negotiate and under a friendly condition. Wow, all of these sort of words, but no one cares. If you have dispute, let's go to court or to arbitration, as simple as that. But those sort of words now carry weight because of a lot of new developments in different jurisdictions in case law. Now, look at this one, it happened in Hong Kong. We call C&D case, we know that because of confidentiality, right? The court judgment will not disclose the names of the parties, so we got it Company C, Company D. Judge may decide to release the name, but both parties can always make a joint petition to say, no, we don't want the name to be disclosed, right? It all depends. All right, in a standard, or never mind the contract, right? When it comes to clause 14, there's normally at the end of a contract is the dispute resolution clause, right? This is the one. Here you have clause 14.2.3. Let's very quickly look at 14.2, the first sentence. It says that the parties agree that if any controversial dispute and claim arises between the parties out of or in relation to this agreement, or the breach, interpretation, or validity thereof, the party shall attempt in good faith promptly to resolve such dispute by resolution. So that's the word shall. That is to say, if you have dispute, must in good faith and very promptly try to resolve it by negotiation. Then the second sentence, you use a discretionary word, may. So either party may, by written notice, to have the dispute referred to the CEO of the other parties. And then the CEO will have to meet up. And then after 10 business days, they will try to resolve. All right? That is the second limb of it. That 14.3, doesn't matter. 14.3, just any dispute, any arbitration clause you can see in any contract. Always say that. So after 60 days, no negotiation, not successful, you will go to arbitration to HKRAC, and then the arbitration is under ancestral rules, full stop. Okay? That is standard agreement. Now let's look at what happened. Right. Oops. Right, this is the one. Question. Things happen. You see, on the day, it was actually on the Christmas Eve, on the 24th of December, Company D wrote to Company C to say, sorry, we have disputes. And then to send a letter to the chairman and the board of directors, to say that we have an issue. And only CC the CEO, right, copy the CEO, to say that we have dispute, we got to help. Then the CEO immediately called back to say, hey, why did you write to my chairman? The 14.2, do you remember? Is that you write to me, the CEO, right? And then why did you write to the board? And then there was some archie-barchie, and then nothing happened, probably because it's already Christmas or something, and the people forgot all about it. Then by early New Year, sometime in January, Company D actually applied to HKRAC and issued an arbitration notice. And Company C immediately protest to say that, protest to HKRAC to say, look, come on, do not accept this case, because this case is not ripe for arbitration yet, because they did not go through my CEO negotiation. Supposedly, the CEO or two companies should negotiate, and they have never done that. But then HKRAC decided to go ahead and then appoint the arbitration tribunal. Right, then the arbitration tribunal formed, and the first question they have to decide is that C, of course, have to file his defense and everything. The first thing he said is, I'm sorry, you should be recused. You have no jurisdiction to hear my case. Says to the tribunal. The tribunal said, it is a case touches on jurisdiction. That is to say, it is a case to say that whether I have the jurisdiction, and maybe I will not be able to hear the case. But the tribunal took the view that no, this is only a matter of admissibility. That is to say, the claim of the D company, whether it is admissible to arbitration. That is the question. Can it be arbitrary, right? Is the real question. So the arbitration tribunal said, look, no, we are going to reform and hear the case. We will decide both. Number one, whether we have the power to decide whether we have jurisdiction. And number two, if it is almost like, I don't know your jurisdiction, you have judicial review, it is called roll-up hearing. You hear the jurisdiction, and you also hear the merits of the case. And as a result, the tribunal decided that it has jurisdiction. Number two, it also held that C has lost and have to pay compensation to D. Of course, C immediately appealed to Hong Kong CFI, Court of Final, took the case to court to say that, sorry, this is a jurisdiction issue. But you know the ancestral rules, the tribunal actually was given power to decide whether it has jurisdiction. But the argument there is, no, we are not asking about that sort of jurisdiction. That sort of jurisdiction is only deal with this case, it's a case fall within this arbitration, this contract for you to, if it is something outside the contract, so you have no jurisdiction. That sort of jurisdiction. This challenge is different. This challenge said that you were not even born yet. There was actually no tribunal because you have not fulfilled, and so the tribunal is not yet formed, that you are not there. You are not there. You can't hear anything. That was the argument. Right then, because they said, why? Because just now, 14.2, remember the word shall, right? Because there's a condition precedent you must fulfill. So, and both parties agree that yes, there was a condition precedent. The question is, which is condition precedent? Of course, D said one thing. Condition precedent is that the first sentence, we have to do it, I can't remember anyway. You have to try to resolve, attempt in good faith promptly to resolve the dispute. That's it. That is the only condition precedent. Now we had good faith, we wrote a letter to you and promptly asked you to resolve. But then, no, you're supposed to give it to the CEO. That is the second sentence. That is discretionary. So one way to show that we would like to settle in good faith is by writing to the CEO. That's only one of the many other options to prove that I am in good faith. So I decided not to do that one. I decided to write to your chairman, copy you. Do you see the argument, right? Okay, never mind. As I say, the qualifying CFI first held that. I want to ask a question. Is this a challenge to the tribunal? That tribunal, you are not even born. You're not there because precedent consideration not yet fulfilled. Or you're only challenging the claim. Hey, the claim could not be heard yet until you have finished all the SAP, all right? So question is it the tribunal you are challenging or the claim is challenging? And in CFI, they held that, no, the objection was really the claim, arguing the claim may have been prematurely go to the arbitration, but did not go to the jurisdiction at all. The tribunal always have jurisdiction because the first sentence showed that all you need to prove is that both parties, because parties' intention is always paramount. So the first sentence showed that this is paramount, both parties really want all disputes to resort to arbitration. That is already good enough for stop. All right? So the losing party will appeal to Court of Appeal. Court of Appeal upheld the first CFI's decision. They went even straight up to Court of Final Appeal. Court of Final Appeal, unanimously, all judges agreed that it was all judges agree that the appellant C lost, right? But for different reasons. Four of them, I think one is our Chief Justice said that it's so useful to differentiate between jurisdiction and admissibility. So in future, if any more argument, we will follow this formula. And then Judge Fogg said, yeah, I concur. The other judges say, Roberto said that. The other judges said, I was very tempted by the other, Mr. Justice Gummo is the one who held a different view. But then, after all, I still think the Chief Justice direction, his way of looking the issue is better. Never mind. Long and short is that all agree the tribunal has jurisdiction to hear, but for different reasons. Is that four of them think that, yes, in future we will follow jurisdiction and admissibility. That's one good way to decide. But Mr. Justice Gummo is the one who said otherwise. So, look, there is absolutely no need. There is not even necessity to differentiate between jurisdiction and admissibility. Just to say that, look at the parties' intention. If the way the arbitration clause is couched is clearly, manifestly demonstrate that both parties want all dispute to be decided by the tribunal, it will be up to the tribunal to decide. Besides, UNCITRAL always mention tribunal has power to decide its jurisdiction. So whether jurisdiction must be including whether the tribunal had been born must also be included, is what the judgment said. All right, that's all. What I want to say is that this case also demonstrates one thing, is that the Hong Kong judiciary, the whole system, is always arbitration. If anything, I remember when I first started doing arbitration 50 years, I'm sorry, I've been doing it for 50 years. 50 years ago, I was a young, trainee, and I had absolutely no idea what arbitration is because they threw me into arbitration case in Hong Kong. I went back home and checked the dictionary. What's the meaning of arbitration? They did not teach me in law school. I swear to God, in those days, no one would teach you arbitration in law school. I really have to ask. But anyway, in those days, every arbitration case, after the award is sued, the losing party always took the case back to the court. On one ground, if you think the arbitrator made an error in the law, you can appeal. Otherwise, facts you can't, right? But as a good lawyer, everybody can build up some argument to say that the arbitrator make some errors in the law. Do you agree? As all lawyers should be able to do that, otherwise you shouldn't be practiced. And so, in those days, all cases went back to court, and then the court was so annoyed, they say, look, arbitration now has become, the court has one more level. Do you see what I mean? Right? It's nothing but one more level of, you just go for a try and then before you go out. So why could, so they keep, come on, go back, don't come to the court, otherwise don't do arbitration. So this has always been Hong Kong's attitude. We are always pro-arbitration, and we don't want people to keep going to court. If you agree to arbitrate, you go ahead and do so. Thank you very much. I overran by 2 minutes, not a big deal. Thank you. Give me a big round of applause to justify my extra 2 minutes, please. Much appreciated.
Thank you very much, Yuan. So thank you very much for all the insightful presentations. I know we're a little behind schedule, but let's dive into our panel discussion. I'd like to begin with a few, follow-up questions from the presentations. Dr. Dwashini, you talk about two CCJ rulings on the issue of immunity from execution of public legal entities, right? So I'm just wondering, what exactly is the effect of these rulings? I mean, does restricting the immunity in the way as ruled by the courts reflect a sort of more pro-arbitration approach by the CCJ, and coupled with the new configuration in the bodies of rules that you've just mentioned, basically, which now made it clear that the judicial control is separate from the arbitration administration. So what does that mean for harder arbitration in the future?
This is for CCJ arbitration, this is to capacitate it to be more competitive, you see, because since it was installed, the main critiques was that CCJ arbitration is very involved in state justice, you see, and that there should be a clear division between, or a clear separation between arbitration and state court. But the main originality of the CCGA is that being the Supreme Court of the contracting state, it's at the same time an international center of arbitration, and we had a clear separation had to be done between its judiciary function and its administration function, which was not clear until the last text adopted by the Council of Ministers. That is for its judicial and arbitration function. Now, coming to the immunity from execution, the whole system of arbitration law is dedicated to promote the attractiveness of the contracting state. And it was not very fortunate to include a provision like this, Article 13 of that Uniform Act, that institute the principle of strict immunity from execution when a state or a public body is involved as a whole. And many traders were against this system of functioning, saying that, look, you say you are a state, but now you are in the field of traders. And when you are condemned, you can put forward the fact that you are a state. And at the beginning, even the Common Court of Justice, in its judicial function, was of the opinion that when there is a ruling against a state or another public person, there is no way to implement the decision because it enjoys immunity from execution. But now, with the evolution, the reality is that as at the international level, if you are a party to an arbitration agreement, when you are condemned, even though you are a state, if the origin of your condemnation is in the private law, then they can restrict your immunity from execution. And that is where the Uniform Act of OHADA stand now, the new uniform of recovery of debt adopted by the OHADA Council of Ministers stand now. And we think with this regulation, OHADA is now at the international standard concerning the 2 points I raised. That's what I can tell you.
Thank you, Doctor. So apart from CCJ, there are other institutions in the region. For example, the African Legal Support Facility, the Association for the Promotion of Arbitration in Africa. You actually served on many of them. So my question is, so how important is such institutional support in shaping the arbitration development in the region, and what is the role of a country-neutral institution like the AALCO Regional Arbitration Centers in the overall picture?
Look, AALCO is an important organization that promotes development. And I think the creation of this regional arbitration center is part of this idea to promote development and to promote instances where that can settle dispute in a way to ensure confidence and promote development. So what an organization like AALCO can do is promote capacity building in the AALCO countries. And even though we in Africa, we have also modern regulations concerning arbitration and mediation, we still need to build our capacity. And in this regard, I think AALCO can be useful.
Thank you, Doctor. So moving on, CM, if I may just turn to you. You have in your presentation identified certain aspects requiring special attention when it comes to investor-state dispute resolution, with reference to the under-trial Working Group 3 report, the concerns raised therein. Can you explain a little bit more about the three possible reform options that you've mentioned? I'm particularly interested in, how does the proposed sort of international court fit in, and how does this sort of new process of challenging the arbitrators work? Could you just explain a little bit more?
Sure. After hearing from Jose and Huynh, I think I actually need to clarify a little bit, guys. It seems that I'm anti-arbitration. I'm not, actually, when I pointed out these concerns. In fact, of course, wearing my hat as the President of Law Society, of course, I'm here to promote Hong Kong as the premier seat for arbitration for the reasons explained by Jose and Huynh. But going back to the actual concerns raised by the Ancestral Working Group, I think to me the solution it's simple, especially for, well, bearing in mind the investor-state dispute settlement mechanism is a very unique public international law tool Imagine that you are actually allowing a foreign investor, when they do FDI, foreign direct investment, in your country, bypassing your domestic court system. You are allowing them a different forum, arbitration, to sue the state, a sovereign state. So this is actually, that's why I said that it may seem a bit unfair to domestic players. So this is a very unique system in international law. So having this unique system, I do think you should have some more safeguards as raised, as identified by UNCITRAL working group. The simple answer to me is number one, choice of arbitrators. You should choose your arbitrators very carefully. Competency, confidentiality, all that, So be careful, especially for bigger amounts. Number two, seat of arbitration, going back, where you actually have your arbitration to be heard. Like I said, Hong Kong is obviously one of the more popular ones, but there are others like London, New York, Singapore, to be honest, But yeah, I think caveat emptor goes back to the parties themselves. They have to be careful in terms of what I mentioned about competency and the ability to intervene by the local courts where necessary. So these are all factors that one should look into. I don't know whether that's a sort of long-winded way to give you the answer, but like I said, Hong Kong is one of the better choice. Thank you.
Thank you, Tim. So on Hong Kong, Jose, you've talked about the legal strengths that Hong Kong enjoys under one country, two systems, and how it contributes to the arbitration development, and from the legal infrastructure, legal system, arbitration law, to the court system, specialty list, to the diversity pool of talents, and also the immigration facilitative measure. Now, indeed, of course, Hong Kong being part of China enjoys another unique advantages of being able to enter into mutual legal assistance arrangements with the mainland, some of which are related to arbitration. Could you maybe briefly tell us something about these arrangements?
I think the one which is probably mentioned more was the arrangement whereby there's recognition of interim measures, because as you know, one of the important things if you're arbitrating, or in fact if you're litigating, is, for example, whether the person against whom you've started proceedings in the end will be good for the money. And so on occasions, one wants to apply to do what is called a freezing order or a Merave injunction, depending on which jurisdiction you're from. In essence, you're asking for certain assets held by one of the parties to the litigation to be held there, so that by the time you get an award, you don't end up with an empty award. And obviously, as part of the one country, two system, one of the great advantages, we were able to enter into an arrangement whereby the orders or interim awards made by tribunals of certain institutions in Hong Kong could be enforced through the courts in mainland China, and that's proved to be extremely effective. So I don't have the statistics. You probably have them, but basically a huge amount of amounts were frozen as a result of orders made by the tribunals here. So that's actually it makes a huge difference, because if you can't do that, you can arbitrate until the cows come home. But if you've got your award in 3 years and all the money is gone, then that's no good. So I think certainly that's a very good example of what can be done. And the other, of course, is insofar as you want to enforce something in mainland China or through other means, because we are bilingual jurisdictions, it's actually very easy to find very good lawyers who are biliterate and trilingual.
Thank you very much. So thank you very much, Jose. So yes, indeed, the interim measures is very important in terms of preservation of assets, evidence, and conduct. And yes, I do have the statistics. As at the October this year, the total value of assets preserved by 71 decisions issued by the mainland courts amounted to approximately US $2.2 billion. So that's the huge amount. So thank you, Jose. So moving on, I mean, Hyun, as you've explained it in very detail, I mean, the new officer regime provides, another funding option for arbitration users in addition to the conventional charging arrangement. And with the third-party funding of arbitration regime also in place, and basically we have a pool of different options, funding options for arbitration. So, but at the same time, you've also very rightly pointed out that it takes time for people to learn about the regime, and it requires education and promotion. And then on this note, would you agree that it is important that legal guides and tools be issued to help publicize the regime, and would you have any observations in this regard?
Yeah, first of all, I have to thank DOJ, thank Clifford's, the department have done a great deal organizing workshops to educate. First of all, you have to educate the lawyers first, right? If the lawyers don't understand what ORSA is, how you expect a client will employ one of these paying pricing mechanism, right? So the lawyers need to be educated, and then in the workshop we even produce a lot of standard model agreements for the lawyers to refer to. Although you had to put in a huge health warning, right? Copy it at your own risk, right? But on the other hand, at least you have something to start with, and also, to be absolutely honest, as I mentioned in LATCHCO, when the bill was passed and the law is that smaller law firms in Hong Kong will have to watch out, because, look, we learn a lot from other jurisdictions, like in the UK, they've been using for quite a long time. But in Hong Kong, smaller, not to say small, but smallish law firms may not have the power and the experience to deal with sophisticated clients. You can imagine that a client who would like to embark on one of the free ORSA payment scheme normally is quite a big corporate. They will have in-house lawyer, don't forget, right? You are not talking about dealing with a consumer, someone who purchased a car and felt unhappy, right? You're talking about big corporate with a strong legal in-house team, but they like to embark on also, right? So if you are a medium-sized law firm dealing with them, you really do need to watch out, right? Because there could be a lot of pitfalls. But yes, we need more education, educating the law firms, then the law firms can educate the clients.
Thank you. And so, thank you very much. Well, I think as the Department of Justice, sees it very important that we issue these guides and tools, because this is very much relevant to one of the points that Dr. Duashin just mentioned, is part of the capacity building. So if I may just invite everyone to go check out our website. On the website, we have two particular important documents about the OFSA, the new OFSA regime. One is on the frequently asked questions on OFSA. It provides, quick answers to common questions on OFSA, and also a very recently published guidance note and checklist on OFSA. Basically, it helps you to check the boxes that you need to check in order to ensure you comply with the relevant legal requirements. So if it's still okay, we could just maybe take another 5 or 10 minutes just to cover a few more points, if it's okay to the organizer, right? Now, fellow panelists, we've talked much about arbitration. Now let's talk about other things. What about the other popular means of ADR mediation? Mediation is on the rising trend, no doubt about it, being recognized as as a less expensive means of dispute resolution, and more importantly, one that can achieve win-win solutions. So, Dr. Duashni, what are your observations on the use of mediation in the Asia-Africa region?
Well, I think mediation is a good thing, and I must stress that there is in the OHADA space a uniform act on mediation. And when I went to the United Nations for the negotiation of the Singapore Convention, OHADA already had this uniform act on mediation. And one of the originalities of this Uniform Act is that even though mediation supposes the intervention of a neutral, you see, that has to assist parties to settle amicably the dispute. The Uniform Act, the OHADA Uniform Act on Arbitration, its originality is that it validates also agreement reached by the parties without the assistance of a neutral. And during the Singapore negotiation, the negotiation of the Singapore Convention, we put forward this originality, and we were supported by other parties, other parties that were also negotiating with us. And that's why when you take now the new and modified model law, ancestral model law on mediation, you will find a footnote 5, according to which a country that make a legislation or that conceive a legislation on this matter could include in the scope of its application even agreement reached by the parties without the intervention of a neutral. So I think because of its flexibility, it's an accurate tool for the settlement of investment and even commercial disputes.
Thank you. Thank you. So what about the Asia and Hong Kong on the mediation front? For the other speakers, I mean, what has Hong Kong been doing, and how can Hong Kong contribute further on the mediation front domestically, regionally, and intentionally? Any of the Hong Kong representatives?
From the Hong Kong perspective, of course, the DOJ has been actively promoting mediation as a means to resolve disputes, and we've, of course, as practitioners, been following up on this proposal quite closely. And obviously, mediation it's very cost-effective, even comparative to arbitration. And I can see a lot of advantages. There are two types of mediation, of course, facilitative or evaluative type of mediation. Both of them are quite effective, of course. But within the law society domain, we do have a mediation list, a list for mediation. We actually have a mediation committee as well, contributing to the mediation work in Hong Kong. The advantage, of course, the parties actually come out with their own volition, using their own ideas to resolve their disputes, instead of a third party imposing a decision on them. So, I mean, personally, I work in a number of family offices, actually. So in many of my daily work is actually not the legal work, but mediation between different branches of the family members. So, so I practice mediation basically every day, and I think it's a very, very effective way in resolving disputes. Thank you.
I'll just chip in very quickly. I think mediation is popular because economically it makes sense, because if you compare with a day of mediation with a mediator, even if you have lawyers on both sides turning up, it's probably less than 2 or 3% of the cost of fighting until the end. And if you settle, it only costs you that small amount. If you don't settle, that 2 or 3% you spent, actually, you probably would have to spend anyway, analyzing your case or doing a summary of what your best points are. So actually, the net economic cost, if you succeed, is amazing. If you don't succeed, actually, it's quite minimal. So I think it's something which is certainly very popular here. And I think both the Law Society, the Bar, we've been doing lots of sessions to train our members. I think we actually probably have more mediators than people who want to have their cases mediated.
Thank you.
Right, yeah. Let me quickly chip in. Yes, I'm a big believer in mediation as well. I'm also an active mediator. You see, there has been talk that there are disputes in mainland, right, involving a foreign party and a mainland party. They could try mediation first in mainland. Not successful, they will come to Hong Kong to do arbitration. This is the way they are thinking they would do. Yeah, basically, mediation has changed quite a lot, evolved during the past 3 years. As I said, I've been practicing this for so many years. When they first started mediation, it's always evaluative, right? Later, then it became all facilitative, and now it seems to be moving back to evaluative. And in fact, so much so that I gave you a talk at the CI after Asia, but it's another day, how AI could help, right? Do you know that AI may help in mediation? You key in the facts of both sides, right, into the case, and then they will work out their, you know, Bachelor and Watner, right, your best assessment, worst assessment thing. They put it in, Ginny will tell you after what sort of likely result you will get, and based on that, you can make the calculation, you know, as to should I settle or not. That is something very unusual. Really, I have a few retired judges. They are very successful mediators. I think you know what I'm talking about. But during the time when they were judges, they're known to be so tough-nosed, very strict-faced. Right? How could you be a mediator with these sort of characters? Oh, no, because I used to be so tough-nosed. When both parties came before me, when I tell them, look, if I were the judge in those days, you would definitely lose. And they would actually immediately take it as far and settle a matter. Anyway, there you are.
Thank you, thank you. I mean, putting on my government officer's hat, of course, from the policy perspective, we've been emphasizing on promoting mediation domestically, as you probably would have noticed from the latest policy address. Domestically, we wish to further promote, deepen the mediation culture by, for example, starting with having standard mediation clauses in government contracts, and also promote private sectors to incorporate similar mediation clauses in their contracts. And of course, regionally, there's much more to be done. For example, in GBA, because it's one country, two systems, three jurisdictions, a lot can be done in terms of once there are cross-boundary disputes, you need to resolve them, and you need to resolve any agreements, for example, mediator settle agreements. So these are things that have to be worked out. And of course, for the Belt and Road disputes, we also think that mediation could be a very useful tool. And of course, internationally, you must have heard about the International Organization for Mediation, preparatory office just set up just earlier this year. That office, I mean, the mediation, that organization, when set up, is meant to be the world's first intergovernmental organization, legal organization dedicated to providing mediation services for settling international disputes. So this is a huge thing for the world. So I think I just want to complete the panel by just raising two last points. Moving on, what about adjudication? We've talked about arbitration, mediation, and we know conciliation, but what about adjudication? I mean, how is it different from arbitration and court litigation? And would any of the panelists be able to raise, any examples of use of arbitration in the Asia-Africa region? Adjudication.
Like mediation and arbitration, adjudication, why not? Why not? I think this is something also in the scope of action of AALCO. You see, AALCO needs to promote all these tools and to build capacity of the parties interested, you see. And I hope the Secretary General of AALCO is around and is okay. So I'm happy he's around. So we expect many from him concerning the capacity building of AALCO states. I mean of AALCO, of the lawyer from AALCO state. That's what I can say.
Okay. Thank you, Doctor. So before I came to that final point, I really want to touch on capacity building. But since I raised the issue of adjudication, I thought I should try to chip in. That is, the Hong Kong government has just, I think it's in late November, gone to the Legislative Council to brief the panel on development about a proposed construction industry security of payment bill. So, security of payment bill. Yeah, there's a particular scheme for the construction industry. It's basically to improve the payment practices in the construction industry and to provide a mechanism for speedy resolution of payment disputes. And within that scheme, one of the proposals is to introduce an adjudication mechanism, whereby an agreed, engaged adjudicator could make a rapid and binding determination. Of course, it doesn't take away the parties' rights to refer the dispute to arbitration or to court, but in the meantime, unless and until there's an outcome from the arbitration or court litigation, they have to agree to that, to abide by that adjudicator's decision. So in a way, it's before arbitration, before court litigation.
You mean the dispute board?
Yes, the disputants have to agree to that. So
it's something like dispute board.
Yeah, so it gives a sort of rough and speedy, quick justice in the meantime. So yeah.
From my point of view, I won't talk about adjudication board, dispute board, and I see dispute board like a way to avoid dispute. Why? Particularly in construction area, because it's an element according to which the people will conduct the construction according to the contractual specification. And in this sense, I think dispute board could also be encouraged because it's a means to avoid dispute. It's a means for the parties to reach construction in the way they agreed according to the contract. So what I said is not out of topic. I mean capacity building, because even to talk about dispute board, you must know what it is about, what is its purpose, and even here, AALCO remains useful.
Thank you, Doctor. So I don't think I have the time to ask further questions about capacity building. Could I just wrap up by saying this? I mean, capacity building is, of course, I think from our discussion, it has made one point very clear. Capacity building of arbitration talents, or maybe generally dispute resolution talents, is essential. And Doctor, you've just mentioned that AALCO in particular could play a very important part in terms of capacity building. And I just want to chip in that, of course, from the Asian and Hong Kong's perspective, from Hong Kong, we've been sparing no efforts in enhancing capacity building. I mean, for practitioners locally and beyond through, conferences, seminars, workshops. I mean, examples include this very forum, the earlier training session of China AALCO Exchange, and of course, we have a training course on investment law and investor-state mediation, and I couldn't just conclude without saying that, of course, next May, we will have the ICA Hong Kong Congress. That is a biannual, regular, important international arbitration conference. So in a way, that's also a capacity building program in a way. So I can see that it requires mutual exchange, mutual cooperation, and I think this basically just embrace or further uphold the Bandan spirit of mutual, respect, peace, and equality in resolving conflicts. So thank you very much, all the panelists, and thank you very much for bearing with us. We're a little late. Thank you very much indeed.
Thank you so much for the valuable insights. May I invite you all, please step forward, and then we can have a photo together. Thank you so much for the sharing. I believe we gained so much insight. So we stand closer together and then have a photo. Let's have a look to the front, and then don't forget the big smile. Please remain on stage. To express our gratitude, we have a tote bag with some souvenirs for you all. We hope you like it. And then can always hold with the bag, and then you can remember us anytime. Let's have a photo together. One more photo. Yeah, holding the bag together. Thank you so much. Please be seated. Thank you very much. Thank you. So may I invite our guests exit the stage, and then please be seated. Thank you very much. So we really can't make it without the support from our sponsors, partners, and also supporting organizations. We would like to thank our Platinum sponsors, the Law Society of Hong Kong, and City Development Law Firm. The silver sponsor, Zhonglun. The bronze sponsor, Invest Hong Kong. Our airline partner, Cathay Pacific. Media partner, Benchmark Litigation, and also our supporting organization. Thank you so much for your support. And also, in order to get updates from us, we would like to invite you all. I believe that yesterday some of you have already done, but we have some newcomers. So I would like to invite you to get your mobile phone ready, and then open your Facebook, type AALCO-HKRAC, or you can just type ALCO. You can find our page. And then please like and follow. Then you can get the information, the update information from us. And also, I believe that some of you have taken some video and also some photo. You can also share in the social media, hashtag AALCO-HKRAC. Please also like our Facebook and also LinkedIn. And then later on, we will upload the photos and highlight video after the forum, and stay tuned. And before we proceed to the next session, we would like to share with you a video clip about AALCO Hong Kong Regional Arbitration Center. Please enjoy.
Two-thirds of the world's population, representing a huge market with combined annual GDP exceeding many trillions of dollars, live, thrive and collaborate in the 47 member states of the Asian African Legal Consultative Organization, AALCO. With our global headquarters in India staffed by diplomats and professionals from member states, AALCO is an intergovernmental organization established by international law in 1956 with a role and voice in the United Nations. The AALCO dispute settlement system has been established since the 1970s to facilitate disputes resolution and settlement, complementing the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. AALCO now maintains 6 regional arbitration centers in the world, with the latest addition being the AALCO Hong Kong Regional Arbitration Center, which was opened here on the 25th of May 2022. Established by international law with privileges and immunities and established as the only regional arbitration center in North Asia, the AALCO Hong Kong Regional Arbitration Center was established with a number of objectives, including to act as coordinating agency in the AALCO dispute settlement system, to provide institutional and support ad hoc arbitration and other forms of disputes resolution, to provide assistance in enforcement of arbitral awards, and to promote online disputes resolution services and the growth and effective functions of arbitration institutions and other alternative dispute resolution services. AALCO Hong Kong Regional Arbitration Center's online arbitration platform, powered by eBRAM, is secure, state-of-the-art, and easy to use with add-on functionalities like AI-powered translation, real-time transcription, eKYC, and other functions to be added from time to time. AALCO Hong Kong Regional Arbitration Center is established by international law and hence truly country neutral. Being physically situated in Hong Kong, China, and as the only AALCO Regional Arbitration Center in North Asia, the center is able to support economic growth and disputes resolution in and beyond this region, leveraging upon its ODR platform and many unique advantages of Hong Kong as an international trade and financial center and legal services and disputes resolution hub under one country, two systems principle. The center is the first arbitration institution in Hong Kong established under international law and to be recognized under the 2023 Arrangement Concerning Mutual Assistance in Court-Ordered Interim Measures in aid of arbitral proceedings by the courts of the mainland China and of the Hong Kong Special Administrative Region, whereby parties to institutional or ad hoc arbitration administered by our center will now be eligible to apply for interim measures directly to the courts of the mainland China to preserve evidence and assets in accordance with the arrangement. Parties seeking help from our center could tap into a strong pool of lawyers, dispute resolvers, and professionals from all over the world. The center strives to reduce the time and cost of producing a fair outcome so that the parties can get back to building win-win relationships and a shared future together. Our center's model arbitration clause is easy to use, easy to understand. We respect the parties' full autonomy. Parties could choose to make use of our optional clauses to decide for themselves whether they wish to use our ODR platform. But now, please allow me to introduce you AALCO Hong Kong Regional Arbitration Center's online disputes resolution platform.
To complement our full range of traditional offline and offline to online services, AALCO Hong Kong Regional Arbitration Center offers a state-of-the-art online dispute resolution platform. Apart from using a computer or tablet, you can literally lift the weight off your shoulders by using a smart mobile phone to log on. It feels good to be able to fully grasp a problem in the palm of one hand. Our online dispute resolution platform is security by design, with two-factor authentication and session-based natural person identity authentication, similar to some online banking apps. All data are encrypted during transmission and storage, offering a safe and secure environment for online video conference and hearing. To facilitate proceedings and settlement discussions, online breakout rooms are also available, and we have a calendar function to assist scheduling. AI-powered real-time machine transcription service is available in some languages to help you take minutes or a transcript. To avoid the high cost and anxiety of lost in translations, our online dispute resolution platform offers AI-powered, pre-trained translation engine that is capable to translate multiple languages, including English, Chinese in both traditional and simplified forms, Russian, Arabic, and Spanish. Confidentiality and privacy are in our DNA and not an afterthought. Parties can use our privacy by design system to receive notices, store and exchange documents using our secured cloud services. We believe every cloud has a silver lining. We've taken care to adopt design thinking for more friendly, intuitive usage and to reduce repetitive form filling. When you're ready for confidential settlement or awards, we are ready for you with e-sign services, an award or documentation authentication system using blockchain. Feel the difference. Perhaps even put your foot up, save on travel expenses, time costs and unwanted distractions as you utilize our online dispute resolution platform to resolve disputes from within your own comfort zone.
Well, I believe you understand more about AALCO Hong Kong Regional Arbitration Center, and then I also believe that you understand how convenient, user-friendly, and also most important, safe, and also trustable for our online platform. So now, to wrap up the event, we would like to invite His Excellency Dr. Kamali Piniparado, Secretary General of Asian African Legal Consultative Organization, and also Mr. Nick Chan, MHJP, to come to the stage. Mr. Chan is also the Honorary Fellowship HKUST and Director AALCO Hong Kong Regional Arbitration Center. May I invite both of you to come to the stage to wrap up our event. Big hands, please.
As directed by my Secretary General, I'd like to thank everyone for coming today, both online and in person. We're most grateful. I know a lot of you have traveled a long way. I know because of time difference, some of you started your day actually 4 a.m. here, your time in the morning. So it's quite tough. And just rather than trying to repeat or summarize succinct points already made by all our distinguished speakers, we won't do that. We will ask for their permission to share their PowerPoints through our website, right? And then there is this piece of paper, A5 paper, on your table, on your desk. I guess you could download the e-brochure for keepsake if you like to, but there's a questionnaire at the end. We'd like to seek your feedback on how we could do better as a team, right? So you've heard much about the Bandung spirit, but no one knows it better than my Secretary General. So if you have any questions, but anyway, I think from today and going forward, let's do what we can to work on peaceful coexistence between nations and between parties, and through arbitration, mediation, adjudication, or a friendly handshake. So we've heard a lot about AI. I see people interested to learn about different industries, perspectives, leaders from the two branches of legal profession in Hong Kong, from the government, from universities, from logistics, from some of the mega infrastructure companies in the world. I learned a lot, and most importantly, we make a lot of friendship over the last 2 days. I know some of you are staying on, so please help our economy. We are most grateful. And finally, from me at least, I would encourage you to help us promote our AALCO model arbitration clause. You can go to our website AALCO-HKRAC.org. So apart from that, I've also heard we heard a great suggestion. My Secretary General says, good idea to organize youth exchange, so that maybe we could explore in the future, in terms of capacity building, how we could get together, young people, young professionals, or maybe even business leaders. We can get together in different places in our 47 member states, and we in Hong Kong, the center, we're hoping to visit Africa next year. So friends from Africa, please let us know if you welcome us sometime next year. We could string it up. But at least the Consul General of South Africa, Mr. Mongono, who spoke for us at the fireside chat, have called up to say, hey, if you guys are interested, please come with him in June. So I hear that's a good time to go. Anyway, to wrap it up, I'll pass to my Secretary General. Thank you. Please put your hands together.
Okay, good afternoon. Thank you very much, Nick, for your kind words. And I think we come to the end of the AAAF, we call the AALCO Annual Arbitration Forums this year. This is the third one. And we, on behalf of the AALCO Secretariat, we are very pleased and grateful that the AALCO Hong Kong Regional Arbitration Center hosts this third AAAF. And we are so proud of the center led by Nick and his team. Yes, I'd like to mention again that now we have 6 regional arbitration centers. And the latest one is in Hong Kong. And all the 6 centers are independent body and effective institution. Even constituted under the auspice of AALCO, it means that the host country enter into agreement as international agreements with AALCO, but all the centers are independent, neutral, and you can trust by their work. And also, AALCO, we are very proud that now we have 6. It means that AALCO is in the regions, in Hong Kong, in Nairobi, in Lagos, in Tehran, in Kuala Lumpur, and in Cairo. We have 6 centers. Through this center, we can promote activities. For example, issue of the capacity buildings, of the new issue of the arbitrations, provide many consultation amongst member states. Even the younger generation is very important because we like very much to encourage the younger generations in the countries to jointly build up the network in many areas. As you know, that AALCO work, now we have around 20 topics of international law. And arbitration is one under the topic of international trade and investment law. And we like to encourage the younger generation to learn and to join AALCO for all the works. And I think that the center here is we call the AALCO Hong Kong Regional Arbitration Center, just opened up last year in May. But during the years, I found that there are many activities, many actions with this center, but we were very happy, very great. And the most important that the center can help AALCO in terms of build or mutual cooperation with the local or regional institutions, for example, the Law Asia, AAL, and other center of arbitration in the country or the regions. And we can see in the future we can provide in terms of capacity buildings, exchange ideas on many issues that as our of common interest. For example, I heard that someone mentioned about the issue of the ISDS mechanism, investor state dispute settlement. AALCO, so we work closely with the ANSI Working Group 3 to seek some perspective of our member state to contribute to the ANSI. And I hope that in the future, perhaps the AALCO Hong Kong Regional Arbitration Center can host some case of ISDS in the regions. It's very important also. I think in many countries in the regions engaged, a part of the ISDS as a party to the ISDS mechanism. So last but not least, I'd like to convey my heartfelt thanks to all participants, to all panelists, moderator, to join these events. It's very important for us. And please keep regularly contact with the center in Hong Kong, and some who came from Africa. We have already the 3 centers in Lagos, Nairobi, and Egypt. And we're looking forward to have another 4th AAAF, perhaps somewhere in Africa next year. And we like very much to go to Africa, because we have 3 AAAF hosts in Asia. The first 2019 in Kuala Lumpur, second one last year in Sharm el-Sheikh in Egypt, and this year in Hong Kong. We're looking forward to go next year to Africa. So thank you very much to all of you. Thank you very much to the sponsor, the supporting organization, and mostly, last but not least, thank very much to Nick, director of AALCO Hong Kong Regional Arbitration Center, Dennis and his team. So please give them a big applause. Thank you so much. Thank you so much. So we are very proud of your work that you have done. Thank you very much, and thank you to all of you. Thank you very much. Thank you.
Thank you.
Thank you so much, and thank you for the encouragement and support from Secretary General, and also thank you, Mr. Chen, for your great work. Thank you for your team. Thank you so much. Thank you. So, thank you so much for joining us today. Ladies and gentlemen, the second day of Asian African Legal Consultative Organization Annual Arbitration Forum 2023 has come to an end. On behalf of the Asian African Legal Consultative Organization, we would like to express our gratitude to all our excellent speakers, moderators, and of course to all the participants here and also join us online. And then thank you, join us. And for those guests who will join to visit the AALCO Hong Kong Regional Arbitration Center, our staff will show you the direction to the shuttle bus. Please gather in front of the backdrop at the foyer. And also before you leave, we would like to sincerely ask your help to fill in the questionnaire to let us to do even better in the future. And also please return the headsets. For the online participants are invited to fill in the online evaluation form too. And also you will find some souvenirs on the table, especially the pen. We hope you will keep it. As a souvenir, you can always remember us. And also, oh, sure. And then, so now we look forward to meet you again at AALCO's events. And thank you so much. And before we leave, let's have a photo all together. So may I invite you all, please come to the stage. Thank you for the audience from the online. Thank you so much. So now we're so happy because we have so many friends overseas. May I invite you all, please come to the stage. 好，我们现在邀请各位嘉宾来到台上，我们拍一张合影。So may I invite you all the guests, please come forward. 现在邀请我们的嘉宾来到台上，我们拍一张合影。May I invite all the guests, please come to the stage. For the guests on the first row, may I invite you all can step a bit backward, and then you can get closer with the guests on the second row. And then we can stand closer